All right, everyone, we are live. Good afternoon or good evening, everyone. We're here for what I hope to be our final voting session for the police reform package. We have one bill on the agenda, which is the use of force bill. Senator Carter. I understand that a significant amount of progress has been made throughout the day. And so what we'll start off with is council will go kind of rehash what I think has been agreed upon. We'll vote to adopt everything that we can reach some sort of consensus on, and then we'll move forward. So we kind of march back up the bill toward the more difficult piece, which is the actual use of force standard. So with that, we'll start off with council. But before, just one quick announcement. So you'll notice that you have iPads on your desk. Those are to remain at your desk, and we're not supposed to touch them, even though they look nice and pretty. They are for if in the event we actually go down to what is it? Stage two, and we have to vote remotely from here for the floor sessions. That is what this is for. So obviously we're not on stage two, so please leave your iPads at your desk. Okay, council, let's roll.
Thank you, Mr. Chairman. So we're working off of the amendment from yesterday, and that is 878-772/1. Again, that's 878-772/1. And it might be easiest to start in order in the bill, and that is on page 8 of the bill. This is where the changes would begin. And, oh, I'm sorry, the reprint. Okay. So if I could direct your attention down to line 22, and Senators Cassidy and Carter, or anybody, feel free to cut me off at any point. Right, we're on page 8 of 11 of the reprint. So between lines 22 and 28, the language would change to read in its current form. It would strike the wording on line 22 and 23 referencing the Office of the Attorney General, and would substitute the Maryland Police Training and Standards Commission, and would also strike the other groups that are mentioned down to line 26. So it would read like this: on or before July 1st, 2022, in consultation with the Maryland Police Training and Standards Commission, each local law enforcement agency shall establish, maintain, and implement policies and guidance for law enforcement agencies on 1. Prohibited actions under 10.801 of the Criminal Law Article, which is the subtitle that's being established by the bill. Principles regarding use of force, including encouraging officers to resolve incidents without using force, using tactics that do not escalate an encounter, continually assessing the circumstances to immediately decrease the level of force and cease all force as soon as possible. Line 7 and 8 would be struck. In lines 9 and 10, it would now read, assessing whether the use of force is appropriate. In line 11 through 19, that provision would be struck and instead rewritten to say, assessing when and how an officer should self-identify, and assessing when and how an officer should issue warnings to members of the public that failure to obey an officer will result in a use of force. May result. Between lines 20 and 22, it would now read, evaluating each application of force independently as a separate use of force, with each application to be separately justified. Going down to lines 28 through 30 would now read, conducting use of force investigations and documenting uses of force. I'm at the bottom of page 9, Senator. And actually, just about to go on to the next page. So on the next page, page 10, subsection D deals with annual inclusion in each law enforcement agency's budget. It requires each local law enforcement agency to include in its annual budget funds for, and I'm just going to read as it reads from the bill currently. Training and assessment of training, including training on interactions with persons who are vulnerable and in crisis while in possession of a knife, an edged weapon, or a blunt weapon. Instead, what would happen is the requirement would be for inclusion in each local law enforcement agency's annual budget. Funds for training and assessments of training is required. I don't have the site in front of me, but it would be the section of the public safety article pertaining to the annual entrance level and biannual training requirements for in-service level training for police officers. So it would cross-reference that section, and the term in crisis would be added as a training requirement that MPTSC is required to develop curriculum for or standards under that section for, and it would require that officers receive training for persons who are in crisis. Moving down, there's a reporting requirement in subsection D. This would require each local law enforcement agency, and Senators Castley and Carter, if there's anything that you disagree with that I say on this one, feel free to interrupt. This would require that every 6 months, on or before December 31st, 2021, and every 6 months thereafter, each local law enforcement agency would be required to post on its public website data regarding the use of force by officers employed by the law enforcement agency, disaggregated by the race, age, sex, gender, ethnicity, color, national origin, religion, and disability of each person on whom force was used, and including the list of items that follow below that. The one thing I'd note as a difference is that in line 20, the term justified is being struck and replaced with force was in accordance with department policy.
Senator Sidar.
I was just wondering, why is that change being made?
Because the evaluation by the local department is not whether force was justified, but whether it was in accordance with department policy. They're just reporting what they did. They don't have to justify it. They just say whether it violated their policy or not. Because, I mean, a use of force may have been justified, but if it was not in accordance with policy, that's what they're identifying. That you didn't de-escalate first, or you didn't whatever. It wouldn't necessarily make it justifiable or not. It's whether it violated policy. Because you can have a use of force that was justifiable use of force, but you still violated the policy in the way you went about it. And that was what we were trying to get out here. This whole section here is about policies, setting up policies, implementing policies, and following policies.
Okay.
I'm sorry, a minor suggestion. Jamie, I think we agreed that we would add the words "if known" at the end of that long list of attributes in the beginning of paragraph D.
I mean, some of these are immutable, but I mean, I guess there are cases in which
Well,
you
we
would know
talked
that
about
they're
religion.
sitting in a dark, say what?
We talked about religion. It may be that the police
Got it,
wouldn't
got it.
know the religion of the person.
Understood.
Include the race, age, and sex of the officer who used force and the person who was the subject of the use of force. Oh,
Because of the smaller departments, it would be totally disclosing everything.
okay, so that part will be coming out then?
Yes.
So it will just be limited to the person who was the subject of the force then?
Well, I think we agreed to do the race of the officer, that we could do the race and sex of the officer, but we weren't going to, isn't that right, Jeff? Oh, the victim, I'm sorry, okay. You're right, and the officer didn't matter, that's right. So this comes out, 8 comes out.
What we agreed to was that we would keep it disaggregated regarding the person that it happened to or the victim, but that we would still be able to include in summary form the officer, the data on the officer. I thought that's what we agreed to. Meaning that we wouldn't have to list it out like Officer A, I thought somebody said, had 3 instances of uses of force, but that in summary form, we would be able to say that of the 45 instances of uses of force, 35 of them were committed by white female officers, blah, blah, blah. That's what I thought we said.
That's correct. That's what we agreed. So you wouldn't identify it by each incident, but the
Right.
report would itself have a summary. So
Right,
we
so-
wouldn't be disclosing officers.
The
inadvertent.
report wouldn't be disaggregated by individual officer, but it would be disaggregated by the race, gender, and sex of the officers that are using force, correct?
I thought that what we talked about was that we're not looking at, this isn't an incident by incident report. This is a report that said we had 20 incidents and then sort of the breakdown of incidents, not by report. And then of all these incidences, you had it by the victim's profile, right? Not by the officer's profile, but by the victim's profile. But we're not listing every single incident here. This is not a by incident report. The department would obviously have to have that data, but the report's coming out in a composite fashion.
And I thought what we didn't really finalize was the additional pieces that initially you objected to, but I explained that Baltimore City does some of this reporting already, which is incidents of excessive force, citizen complaints, determinations and citizen complaints.
I can't hear you, Senator Carter. I'm sorry. I got this fan thing right behind me. It's not.
So, I feel like the microphone is so incidents of uses of force. Yes, we want the data disaggregated regarding the recipient of that force, who received the force, understanding that every use of force is not a citizen complaint, right? But then we wanted to have also, well, I wanted to have the number of citizen complaints and the way that those the number that resulted in a finding. We wanted to have the number of incidents where individuals had to receive medical attention because of the actions of an officer, because of force used by an officer. And I sent you, Jamie, only recently, though, the specific language from the Baltimore statute that's on the Baltimore Police website. And I only highlighted 1, 2, and 3 because they cover these areas.
And that's correct. We did limit this to either where there was either a complaint or where there was a hospitalization. because we didn't want, I mean, we looked at it, every arrest is a use of force, and every time they put their hands on somebody, we didn't want to get this ridiculous report with so much information was useless. So it was a citizens, somebody complained of
still-
excessive use, or there was a serious enough injury that somebody was hospitalized.
I still see it as sort of, though, you still get the total number. So there were 500 incidents of force. Of those 500, there were 55 citizen complaints. Of those 55 citizen complaints, 3 resulted in some type of action taken regarding the officer.
But just to be clear, but of the 500, that would include that equals, that number 500 in your example would equal both citizen complaints plus serious injury or hospitalizations, right? That's those two add up to equal to 500. Yes, okay.
Well, and correct me if I'm wrong, but I guess then would we just add to the list that's of items on D and just say for a number 9, whether the use of force resulted in a citizen complaint?
Well, somehow that's got to come in the top. Because that's defining the universe. Because we want to, I mean, it's almost like, what do you have to report? You don't have to report every use of force, otherwise we're going to have every freaking arrest for DUI, every, jaywalking arrest. It's got to just be the ones where the citizens complained. What this universe is citizens complained or somebody was hospitalized. Either one of those ought to be in this report. Or I'll go with that, or death.
Yes, I just want to be clear that we are saying that we still want to know the total number of instances of force, but the breakdown with the specific disaggregation of data would be limited to those ones that resulted in civilian complaint, person going to the hospital, death, blah, blah. But no, not every single time a taser or a weapon is drawn, whatever, would that need to be broken down. Only in the cases of civilian complaint, injury, hospitalization, those things.
Okay, I'm sorry, I'm just not, we're saying 2 different things, because the total number would not just equal every use of force to accomplish an arrest, because every arrest is a use of force. The total number will not include every use of, you keep saying that every use of force, but we agreed that we were not going for every use of force, or we'll have every arrest would be reported in this. It's citizens' complaints or injuries, hospitalizations, right?
And what I mean is that, no, I don't intend for the total number of use of force to have to be set, for there to be a report, we had 500 uses of force, this number was, and disaggregated to who was the victim and blah, blah, what happened. But what I'm saying is there's no harm in knowing how many they had, how many instances there were. I mean, I think the officers, the departments keep that data, don't they?
So if you're saying that every arrest is a use of force,
Every time you put your,
Okay.
this says use of force. Every time you
I'm
put
just-
your hands on somebody is a use of force, so.
so correct me if I'm wrong, but then that arrest data is collated in public, right? I mean, that's, so you'd already have that.
I don't think that that's helpful, but I think departments specific guidelines for what they consider to be a use of force, and it's like when you draw your weapon, when you use a taser, when you punch somebody, that kind of thing. Like it's more than just an arrest.
I just, in order.
At the end of the day,
Yeah, no, I like.
what's most important is the other part, but
Yeah.
I thought having a general total number might be also.
So you have a whole universe to compare it to and understand. I get what you're saying, but I think that information is already publicly available. But you could do that analysis afterwards as long as you captured this data. But maybe I'm right. So let's do Senator Sidnor and then Senator Bailey.
Thank you. A few questions. One, going back to bill page 8 of the new B under 3-523. The community is being pretty much stricken, and it's going to be the Maryland Police Training and Standards Commission. And whom else did you mention? Just them, okay. So could you remind me the makeup of that particular commission? I know it's legislators on it. I know it's a lot of police, and that's okay.
What's the total number?
It's 24 total. There are 4 to 6 civilians that are on that panel,
Okay.
and they're from the community.
And okay, so and so my next question was going to be, because I'm assuming these categories of people were put on there so that they could give their input, especially the victims of police violence, to give their input into this process. So I'm wondering, I guess the policies that will come out of this committee, seeing how this isn't necessarily a department, are they looked at as like regulations that would come out under COMAR, so you would have a period of public comment and the like?
Yes.
You do
Yes.
you do that?
The Police Training Commission has to publish everything for public comment.
Okay. Thank you.
And also, just to know, unless there is a specific personnel matter occurring there, each meeting is open to the public. So anyone could actually attend the meetings, and it's easier now because they're virtual.
Okay.
But they meet quarterly, and so any citizen can meet there, but they are, they are published. So in
Okay.
1016, HB 1016, everything that we specified in that bill, committees were formed, and they had to be brought back to the body, and then once they agreed upon it, it had to be published
Okay.
before it came back for an actual vote. So.
Okay. Thank you. Moving to bill page 10, where we're on line 19 and 20, where we're changing justified to, I guess, whether or not the force was against policy. I'm curious, one, whether or not it should be more specific and say which policy justified that, or that it wasn't against. I mean, I'd like to be able, if I'm reading this information, I'd want to know what policy, in my mind, justified that officer's use of force, number one. So I think it would have to report out whether the agency determined the use of force was in compliance with policy 1-2 or something like that. I mean, I'm looking to be very specific. And secondly, I know when we had our conversations, I think about the bill that I had dealing with the inadmissibility of evidence. One of the things that Senator Castley had suggested, which I thought was a real good idea, was ensuring that reporting was standardized. So I don't know if there's anything currently within this that talks about a standardized way that these police departments are going to be reporting the information upwards. So I think he had made the suggestion last week on a piece of legislation that the legislation placed the duty upon the Maryland Police Standards and Training Commission to create a report that would be used by law enforcement as they report this information. And I think that if it's not in there, that would be helpful. That's it. Thank you.
I think the senator makes a good point. I mean, the way this comes out, right, we're struggling with this, but a uniformity is a good idea, and if, rather than leave it up to every little police agency to be creative, I'm sure they would appreciate the Standard Commission just saying, here's your template, here's how you report these, and here's the graph that creates. I think it's a good idea.
I agree with that, and again, that's should be the role of that Training and Standards Commission. That's what they do. Uniformity. They have people making sure everybody's certified, and you have that one repository site where you can grab it anytime you need to. So.
Well, I guess it depends if, so the way that it's drafted right now is that each agency would post it on its public website. But I guess is the goal just that MPTSC would have a model format that information would need to be posted on each website in, or that each agency would report that information using a model sort of reporting mechanism. And actually, one of the other bills this week dealt with something similar to that. But the requirement was for, I believe, MPTSC or Governor's Office of Crime Prevention, Youth and Victim Services to come up with the report based on that. It's just that the mechanism that was used to report that data was going to be uniform.
I think the latter makes sense.
So have a statewide report published by Governor's Office of Crime Prevention, Youth and Victim Services.
I mean, it would be helpful to have it all in one place.
Senator, I know later in the bill we talk about making sure that stuff is filed. I guess whoever's supposed to make sure it's all filed ought to be the. Wasn't there an entry in here that says that somebody has responsibility for making sure it's.
Right, there is a compliance section, and I think, and correct me if I'm wrong, I think the idea was going to be that MPTSC would notify the local law enforcement agency if they hadn't reported, and then there would be a 90-day grace period if they were out of compliance.
As long as it's the same, I would think, so we're not paddling this back and forth between two different groups. I mean, if they report to MPTSC or the GOCAP or whatever, give it to one of them, let them process the report, let them tell the agency you didn't comply, and just keep it all with the one rather than batting it back and forth between two.
And that compliance not only would apply to the report, because it says that it's the entire section, that would also apply to the policy development that's covered in, I think it's subsection B. But then if the law enforcement agency didn't comply, then they wouldn't be eligible for funds administered through the State Aid for Police Protection Fund.
Piece, because I can recall speaking with some of the agencies who have said that some of these police departments, they're not submitting information like they should, and without something to hang over their heads, they really had no way of making these departments submit the information. So I like that last piece.
I did want to confirm. I guess the idea with the reporting is that it wouldn't include any personally identifying information about officers or individuals on whom force was used. That was okay.
All right, I'm going to get Senator Bailey.
Thank you, Mr. Chairman. So in this section that we're talking about each type of force used would have to be reported, and the reason for that force used. And I think we did have some training on force continuum. And the first type of force that is used and recognized is officer presence. The second, right, is verbal commands. They are definitely a use of force. So by saying this, what we would be recording is any time that a police department had contact with any person, that would in a sense be a use of force. Right? That is under the force continuum. You can go from simply being in uniform to lethal force as the way that it portrays, right? And the way that it works out based on what happens in that situation. You don't have to elevate up in line. Hopefully you would go in line, but the fact is you could go anywhere in between depending on the threat and the imminent threat that you were facing or was facing other individuals. So I do think that that it is problematic to put in there that each time force is used, no matter what the force is, because in that situation, we would just make them report every person that they were in contact with.
Clear that it's use of physical force. You can say it out loud. I mean, you could say that. That's what the intent was, right? Or no? Is that?
I mean, so is the idea to say physical?
Does that work? Does that work? Yeah.
So I think I think the easiest way is to have a standard applied across the state. We were just talking about the Police Training Commission, and I think that standard would be the best across the board. Right now, the only place that becomes rather problematic is some departments have different tools than other ones do. Okay, I give you a perfect example. I spent some of my time on a boat. Well, listen, a taser's electric. You sure in the world wouldn't want to use a taser on a boat, right? Everybody's going to get lit up. So the situation is they weren't available on the boat. So I was real happy when we got OC spray, right? Because when I first came out, you were from open hands to closed hands to strikes to firearm, right? That was your force continuum. And because we didn't have batons, we didn't have OC spray. So the use of force continuum with training has become much better over the years. It is not the way it used to be. So I think there should be, if we're going to require this, it should be for some use. Now, in my familiarity with the police departments I worked with, we're talking about documentation. I know for a fact every time we were in an elevated use of force, we had to write very detailed use of force reports. And I think in our departments it was all required. So, I don't disagree with the fact that it should be required to be documented. It covers the liability of everyone, but I don't know and that's what I'm saying. Clearly, officer presence alone, just a uniform, stepping out in uniform with a badge and a gun, clearly is taken by a lot of people as a significant use of force. And so I think that we should really say what we want here.
So we're definitely struggling with getting this right, and I just want to put back on the table what I thought to be the sponsor's original idea, which is what I thought was a good one. Senator Carter sponsored a bill that required Baltimore City to report every use of force that resulted in death, hospitalization, or a citizen complaint. And I think that captures not every use of force, but really serious use of force. And if we can't define the broader category of use of force, let's at least capture and report the ones that have something serious associated with it, either a perception by a citizen that the use of force was excessive, or a result that was bad, hospitalization or death. And so I'm happy going round and round on this stuff, but I think we might have already hit on what we're trying to do in Senator Carter's original bill. Not this bill, the previous bill that we've already adopted as law.
So, could we just borrow the same language from the current statute?
Which bill are you thinking of, Senator White?
It was House Bill 773 of 2015, and I sent you a report that has been done in accord with it and highlighted that in the report, Roman numerals 1, 2, and 3 are the significant portions that deal with those issues.
So she sent it to your email.
Okay.
Yeah.
If you just borrow that language.
She knows every bill she ever.
That's pretty good.
No, I had to look it up today. That's how I remember it.
I can't remember what I did yesterday, let alone.
I couldn't remember at first.
You got it?
It was House Bill 771, but
Let's read the.
let me just pull that up real quick, Senator. So this required that on or before January 1st of each year, the police commissioner of Baltimore City was required to report the following information concerning BPD to the mayor and city council of Baltimore in accordance with 2/1246 of the state government article. As of December 1st the previous year, the total number of sworn police officers in the department, the number of sworn
Everything that was required, we don't need in this bill. I just wanted to get to the language, which I think is Roman numerals 1, 2, and 3, under a section of civilian complaints, injury.
let's see.
But you can read it if you want to, but to be honest with you, I wouldn't open up that can of worms because the more I was reading it, I was thinking, oh yeah, this would be good too.
Let's see. You were absolutely right, Senator. The number of instances of use of force that resulted in the admission of a civilian to a hospital when the injury occurred as a direct result of the officer's actions, and also the number of civilian complaints about the use of force by an officer.
At least the first one.
Just the first one?
I'm asking. That's what I think. But what do you think?
I like both, civilian complaints and hospitalizations.
The second one, in our version, should say against all officers. So just to make clear again that we're not specifying individual.
And this would be disaggregated by race, age, sex, gender, ethnicity.
Complaints overall. I mean, we're not listing every complaint, we're giving the gross numbers and then breaking the numbers down by race, right? It's not a listing of complaints. We agreed that was not there.
Right, it's a look at the entire pie. So if you had 500 uses of force that fell into this category, you would see that, just as an example, 51% or 60% involved situations where the individual on whom force was used was male, and the percentage that was female, and then also by race, ethnicity, religion if known. All of that if known.
And then, according to this, charts about whether it was in accordance with policy or not in accordance with policy, whether it was the percentages with policy, not in accordance with policy, right? And a chart that would say reason force was used, simple arrest, prevent harm to civilians, something like that. But
So I'm just going to make a note to use that that language, the number of instances in which use of force that resulted in the admission of a civilian to a hospital when injury occurred as a direct result of the officer's actions, and the number of civilian complaints about the use of force by an officer.
that's your universe.
Okay, I'll use that as the template for the lead-in language. A, 2, 2, and 3. Okay. Yeah.
Yeah. So the motion is to adopt, where does the section start?
Section 3-523, located on page 8 of 11 of the reprint, with the changes that were just discussed.
Is everyone okay with that? Okay, good. So it's been adopted. All right.
So next, actually, on page 11 of 11 of the reprint, all of 3-524 would be getting stricken.
Say that one time.
All of 3-524, that new language would be struck.
Page 2. Up to 3-801. It's duplicative of what's we're going to get to next. It says in a different, you're going to find out as we move forward, this language is in there twice.
Okay.
It's in different ways.
Senator Carter, squared away? Yeah. Okay, got it. All right, so the motion's to strike. So on page 11, so 5-24, all the way over to page, this is not a numbered page, but all the way to section 3-801. Is everyone okay with that? All right, good to go.
There was further discussion, actually next into 3801. If you turn to the next page, there was further discussion for subsection B, which currently reads, subsection A of this section applies to a disclosure that is otherwise prohibited by law, or a disclosure of information that is confidential by law, only if the disclosure is made exclusively to the Attorney General, is in writing, and contains information that's listed out in a few items there. So there would be an addition to also cover disclosure of information that a law enforcement officer knew or should have known would impede an active investigation if it is made exclusively to the Attorney General under those circumstances that I just described.
Is that to get around the conflict of interest when you have like state police or something?
But ruining an investigation that's in progress by being a whistleblower.
No, I know, but if it's I guess if it's a confidential disclosure, is it because there's a potential conflict? It would be, there'd be a potential conflict? No?
I haven't gotten to that yet. I need to...
Got it. Okay. Okay. Understood. Okay, but if it's confidential to only, I'm just wondering what, I mean, I like it, it's fine, I want to know what circumstances that would arise.
So this was generated, I think, by the chiefs who were concerned that if someone learned about circumstances of a confidential investigation and were to spill the beans to the newspapers, it could impact the investigation, but it would be protected under the bill unless we did something. So we added it to this provision, which said such disclosure can be made if it's something fraud or something associated with the investigation. It can be made, but to the Attorney General and not to anybody else.
That it would impede an active investigation.
So you're adopting the new language?
I did not say likely. So, I'm sorry, how would that read, Senator? I didn't say likely to impede, but we could add likely to impede.
And I wrote that down, but I may have made it up. I'm sorry.
I'm sorry, Senator?
There we go. I also wrote down is likely to impede. And I think it makes sense.
So in subsection B, it would now read, subsection A of the section applies to a disclosure that is otherwise prohibited by law, a disclosure of information that is confidential, or a disclosure of information that the law enforcement officer knew or should have known would impede or was likely to impede an active investigation.
So motions to adopt. Is everyone okay? All right. So that carries. All right, let's keep going.
Striking 3804, and that takes me to, it was. And I believe that takes me to the end of where I think there was,
Consensus.
right,
Let's start where there were points of contention.
so,
Just one little piece.
That's how it starts in 3 hours.
I know.
Come on, guys.
He's about to start right now.
I think we're at page 7, 10803. And this is duty to report and duty to intervene. In subsection B, the bill provides that an officer who knows or reasonably should know that another law enforcement officer is using excessive force or intends to use excessive force shall make reasonable attempt to intervene, to terminate, or prevent the other law enforcement officer's use of excessive force. And then the following section provides for the duty to report for the enumerated offenses or acts that are listed in the items below.
Let's just start with the intervene piece. Did you all reach consensus between Senator West and Senator Carter on that language? You did? Yeah. Excellent. Did we adopt that yesterday? We have not adopted that yet.
Yeah, Chris has an amendment on this.
All right, can you explain, we did?
Yeah.
I don't think we did, because remember we broke, that's where we ended last night. So can someone just read the language and then we can adopt it then? Do you have it, Jamie? I don't. Okay.
Because he just sent it by text, I think, this morning. He said he wanted to strike the word clearly, and I said, that's fine. Isn't that the technical amendment to your amendment?
Okay, well, let's hear him read it, and then we'll.
A law enforcement officer who knows or reasonably should know that another law enforcement officer is using excessive force or has expressed an intent to use excessive force shall make a reasonable attempt to intervene, to terminate, or prevent the other law enforcement officer's use of excessive force. So we're striking out the word intends in line 16 and replacing it with has expressed an intent.
Move favorable.
Motion's been made and seconded. Is everyone okay? Jamie, you want to read it one more time, or is everyone okay with this? All right, we're all good. Great.
excessive force means a physical force that under the totality of the circumstances is objectively unreasonable. And we don't say who it's objectively unreasonable to. Normally, that's interpreted as objectively reasonable to the usual language, that it's an officer on the scene, or with something to that effect. It's not objectively unreasonable to the average citizen, it's objectively unreasonable to a reasonable law officer.
So, to be quite honest with you, with the different drafting, I'm not sure if my intent was lost someplace, but I know that the original drafts were to change the standard from reasonableness to necessity. And so I know that Senator Castley is arguing a different point here, but my request, not only here, but I have some amendments that I drew up too, that catches it in another place, is that we would use the standard of necessity, that in this section excessive force means force that under the totality of the circumstances is unnecessary or not. I think necessary or proportional are the terms. So if it has to be necessary and it has to be proportional to whatever the situation is. I just want to make sure that we aren't inconsistently defining force, excessive force, and lethal force differently with different terms throughout the bill.
Did we adopted that language actually? We just did. Yeah. All right, go ahead, Senator Castley.
Just strongly oppose that request. Now this is really Monday morning quarterbacking what the officer did. It's exactly what the Supreme Court said that is not really fair to try to do, which is to put ourselves, sort of Monday morning quarterbacking, that recognizing that these are split-second decisions, which is why it's just the broader objectively that it's an objectively unreasonable or reasonable, however you want to do it, to a law enforcement officer, a reasonable law enforcement officer on the scene, and to say that it has to be proportional and that it has to be, now you're really putting a standard of care in there. It's the entire analysis that it's just totally inappropriate. I think that's the wrong way to go, to say it has to be necessary and proportional. Every officer would be subject to extensive critique and criticism of every little action they did as to whether that action was absolutely necessary and whether it was reasonable. I'm sorry, whether it was absolutely necessary.
Thank you. I'm just trying to think of a scenario or a circumstance where we would ever want anyone, but particularly a police officer, because that's who we're talking about in this bill, to use force that wasn't necessary or when it wasn't necessary to do so. And then when it is necessary to do so, where would we not want it to be proportional to the need to use it, proportional to the harm or threat of harm? I don't understand why we would ever want anything less than necessity when it comes to the use of force.
So I've been thinking a lot about this, and I think necessary is a perfectly good word to use here. And I think it's the right word. But I do want to object to proportional, and I'll tell you why. So if someone is coming at an officer with a knife and the officer shoots back, that is disproportional because he's shooting someone with a knife. In Montgomery County, we're very fortunate to have a number of women on the force. But if a 5-foot woman is getting beat down by a 6'5", 300-pound man and believes reasonably and objectively that her life is in danger, and she shoots that individual, that is disproportional. He's using his fist and she's using his gun. So proportionality is not the right word that we're looking for. I think if we stick with necessity, we're going in the right direction here. Most states who have decided to make dramatic change in light of the events that we saw over the summer have used the word necessity. I think as I pulled up the 50-state survey that NCSL has, and I'll check again, but they allow text searches, and I don't think anyone has used the word proportional. And so, I think we're halfway there. Well, I think we're all the way there by using necessity and not proportionality.
Yeah, my question, I guess, is what does that mean, necessary force? How's that defined? Because I'm looking up, I'm trying to look at how other states people define excessive force. It seems like what we're trying to get at. Like, here's one. Excessive force can be defined as force that is used which exceeds what is necessary to gain compliance or control a situation. But if we're going to reuse the terminology necessary force, I feel like we need some sort of definition. I actually feel like we're just trying to define excessive force, and maybe we should just define that. But I feel like on this we should be very clear in our guidance what it means, because I'm afraid otherwise that, I don't want a situation where police become afraid to apprehend people or do what's necessary. So maybe I don't know. I'm a little worried that necessary doesn't give us much more guidance. Well, the one I just found online, granted, there could be better ones, but I'm just searching around. Excessive force can be defined as force is used which exceeds what is necessary to gain compliance or control a situation. I mean, maybe that's the key, is we define excessive force instead of the opposite and try to define what is necessary force.
Senator, are you good? You're good? Senator Carter.
Perhaps for this section, proportional may not be appropriate for this section, but I'm not sure, because my concern is that what we want to ensure against is that it may be necessary to use force, but it may not be necessary to use a gun where there's, an unarmed person, or it probably could be handled with something less than a shot. So when I say proportional, I'm concerned because, force could be absolutely warranted, justified, necessary, but I'm concerned about the leeway, that the great latitude there might leave for there's a world of difference in levels of force. And so, I guess you could say necessary and not more than, I don't know how else to say it if there's another word.
There's another one here. That's the definition
From New York, isn't it?
I don't know where it was. Here's one for the International Chiefs. It's similar. Amount of effort required by police to compel compliance by an unwilling subject. It's kind of similar. The one I read before was, I don't actually know where it's from, to be honest. I just thought it was good.
So in this particular section, what we're doing is we're coming after the officer who observed this and saying you have to make a report. So this person is observing a use of force, and they have to look at that and say this is objectively unreasonable. That's a certain mental calculation. Then they also have to go through and say, is it necessary? Which is a whole different calculation. Do we I don't know what that officer knows as far as, did you need to do that? It's another addition. I mean, there's a reason we're saying it's both unreasonable, which means it's something that another law officer, a law officer on the scene who's reasonably trained and looked at all this said, I wouldn't do that. So that's the first thing. And then we're saying, but also it's unnecessary. And I'm not sure what that brings you in this context, because if the law officer looked at it and said, this is unreasonable, then they should report it. And then we're going through this additional hurdle of necessary versus unnecessary. And I don't know what the purpose of that is in this section. Thank you.
So I was just looking here when we talk about this, and the Congressional Research Service that did a lot of work on this, and they talk about, they use one term, reasonableness. With respect to the reasonableness of particular uses of force in specific cases, some trends in case law exist. It's all about case law. It's all about generally deemed reasonable. It comes down to the fact mere possession of a weapon does not always justify the use of deadly force if there's no indication of a threat. More broadly, the courts have shown willingness to defer to a reasonable officer's judgment. That is the way that the courts have ruled this. That is the way that the officers that are out there have been trained. They know the difference between a reasonable use of force and an unreasonable use of force. Right? That's the way they have been trained. I don't think it's appropriate to right in the middle say, well, we're going to change the words. Because what that's going to lead to, is that going to lead to court decisions? Now all of a sudden we're going to be talking about the different words. We're going to be changing it. I think reasonable is a term that everybody's familiar with. I think we should stay with that term.
Say yes, Senator.
So this one does use the word necessary, but it spells it out more, necessary to gain compliance or control a situation. So at least it spells it out a little more. I just think we need to spell this out a bit, not just use either reasonable or necessary. We got to spell it out. And the whole idea of all the terms you look at, it's all the same about it's the amount of force needed to basically control a suspect or stop a situation, and not more than that. That's what the international chiefs, that's what everyone I can look at is sort of defining what excessive force is. That you're giving the officer, obviously, the latitude to control the situation, control the suspect who's not complying, but not force above that.
Though I get troubled by that standard because it puts us, it gets back into what Senator Carter was talking about, that it's proportional. The Supreme Court was really good about this, saying we're going to look at the totality of the circumstances, whether a reasonable officer in that situation would say it was reasonable or not. And now we're adding on words about necessary. And I guess if you say, well, you acted reasonably, but you know what, that was more force than was necessary. And so we really get into splitting hairs there. And now I'm an officer on the scene, and I conclude, I look at that and I thought, well, that force was not unreasonable. And then I have to go through the next thing, goes, well, yeah, but it wasn't necessary. And because it has to be both reasonable and necessary. And what do I go through? How do I decide that force is necessary? If I say it's reasonable, and now I'm going to say, but it's also necessary. I'm just asking, what's my calculation? How do I distinguish between that the amount of force you use was reasonable? Seems like necessary gets into more of a Monday morning quarterbacking of, Yeah, but you could have done something else. You couldas, you wouldas, you shouldas, and then we get dead people, so.
But they would know.
First, I'd like to thank you, Mr. Chairman. I'd like to preface it by saying I'm pretty comfortable with A, but this is looking at another state. You could say that there is no reasonable alternative to the use of force that would prevent serious injury to the officer or another person. That's just another state's approach. You're talking about a qualification. Did anyone hear what I just said? Okay.
Thank you, Mr. Chair. I'm looking at the National Institute of Justice website, which is part of the Department of Justice, and they say law enforcement officers should use only the amount of force necessary to mitigate an incident, make an arrest, or protect themselves and others from harm. So that last piece is the part from Senator Huff's statement that I thought was missing. So I would be comfortable with something, either what we got right now, or if you want to replace it, excessive force is force that exceeds what's necessary to gain compliance, control a situation, and protect a law enforcement officer and others from harm.
Senator Hellman and Senator West.
I think so. Amazing how that happens.
We use different words.
Very similar. What'd you say?
We use different words, but we said the same thing.
Oh, no, you can go ahead to Senator Carter. I'm
Me first? Okay. Look, I just wanted to, I think it came up, I don't know who said it, but look, I think the way officers are trained is simple. It's the force continuum. I think Senator Bailey mentioned it first. The rationale on what you implement at a scene is based upon your training. You're going to react to how you train. If you know the resources you have at your disposal, one is your presence when you get out of that car, two is your verbal commands, three is your hands-on, four is whatever, where it could be OC spray, it could be a baton, four maybe, then it may be your taser, and then finally it's your firearm. That circumstance will dictate that. Your ability to articulate what occurred there is in your report that you filed. When I pulled up to the scene, I chose to engage this circumstance, to gain control of this circumstance in this situation, to use this resource that I had available to me. And that officer has to be able to articulate that. But that officer should not be taking, where a circumstance may get you, may be necessary to go hands-on and take a person down because the person doesn't have a weapon, you need to do what you need to do, versus taking out your gun, because trust me, folks, once you take out that gun, you can't put it back in your holster. So that's where training comes in. You resort back to your training. Every agency has annual training, and part of that annual training is officer survival training. Circumstances, situational, not just to shoot, no shoot, but you go physical with folks to understand who you are, what capabilities you have to control a circumstance. And again, your training also should teach you that controlling an individual doesn't necessarily always equate to controlling a circumstance, a situation. Because when that happens, then again, it's almost like you pull that weapon out. Now you put your hands on someone when you necessarily didn't have to. So, I think I don't know what terminology we're looking for, but again, it's basically using the use of force only necessary to stop a threat to the public, to yourself, and to others. And once that occurs, then that's it. You don't go beyond that. So that's pretty much it.
I think so. Senator Carter, I like the Baltimore County Senator solution here. So if one of you could just read that one more time, because I thought that was pretty good. And then Senator Carter, I want to get your thoughts on it. But
You have the NIJ. I have Vermont, a variation of Vermont.
Yeah, the tool that Jamie sent out earlier is actually really helpful. You can do word searches, and you can see what every other state has done. It's pretty good. But go ahead, let's hear it. Senator West.
Oh, there are two senators from Baltimore County. I didn't.
Yeah, but you both had pretty much the same idea, but
So it would say, excessive force is force that exceeds what is necessary to gain compliance, comma, control a situation, comma, and protect a law enforcement officer and others from harm.
I mean, I like that, and it matches up, I mean, look, and other states, I like that, other states have used it, and it matched up with the international chiefs used to define to their officers. It essentially was close. Everything I've been looking,
I'm going to ask him again.
I like it.
Excessive force is force that exceeds what is necessary to gain compliance, comma, control a situation, and protect a law enforcement officer and others from harm.
So this is, I'm putting my own spin on it slightly, because has to do with deadly force. So I just said the use of force is necessary when given the totality of the circumstances, an objectively reasonable law enforcement officer in the same situation would conclude that there was no reasonable alternative to the use of force that would prevent death or serious bodily injury to the officer or to another person.
Yeah, the first, I think.
They cover the same. Okay,
Hers
good.
sort of adopts the standard that I'd like, I'm hoping we're gonna go a little bit more strong. I just wanted to add to the equation that, not that anyone here cares, but
We all care.
the congressional law that was passed by the House but not the Senate, the George Floyd Act, did elevate the standard of reasonableness from reasonableness to necessity to prevent death or serious bodily harm, and also mandated that deadly force be used only as a last resort after de-escalation had been attempted. So I think that we are already there, I think, because we're all kind of agreeing, I think, or most of us, to force only the force that's necessary. With Senator West's provision, I think it's a little better than the one that Senator Hellman read. It gets closer to this. If I have any concern at all, it's just that, I guess it's, I mean, sorry.
Let's move it.
I'm not I don't want to sound like a lunatic, but it says only the force necessary to do these things. The three things that you mentioned. Read it again, please.
Excessive force is force that exceeds what is necessary to gain compliance, control a situation, and protect a law enforcement officer and others from harm.
I mean, that covers everything. Anything else? I think that's good. It covers everything. It's saying that to get if the suspect's fighting back, it covers that. It covers if the suspect's going to believe a police officer injure them or somebody else. I mean, I think I'll second it.
Don't,
It's
just
open,
a
yeah, of course.
second.
Of course.
The difference between what what Senator Hellman had and what Senator West has is Senator Hellman's explains whose reasonableness, how you determine reasonableness. Senator West, you could say, well, that's just what the individual juror thinks. What Senator Hellman's makes clear is we're covering reasonableness and unreasonableness from the perspective of a law enforcement officer on the scene under the circumstances. It's much more clear from hers, and Senator West leaves that entirely open. I think it's a major difference and one that we should not gloss over. You ought to hold the cops to the standards that the Supreme Court does.
was gonna say though, he doesn't use the term reasonable. That's out now. His term.
If you listen to how Senator Hedelman's,
I know, I heard that, and I think.
but it's a perspective. It's who's judging. It's
I know, but I
how do you
think it's
determine
more-
that?
I don't want-
Is it me, the juror, who's never been in harm in my life, or is it from the perspective of a law enforcement officer who's going to have to come in and say that was totally inappropriate or that was justified?
I mean, I think it doesn't say who's standard. It doesn't say who. They'll have to look at their department procedures and to say it was necessary via department procedures. But I like what Senator West is saying because it's not subjective. It's very clear. It's very plain. It's very.
It's from the perspective of who? Who's saying that the officer's conduct is reasonable? Who?
Because it'll
whose
have
standard?
to be necessary via their department policies. It's not going to come from Joe Schmo the public. It has to be what their department policies are.
No. Now we're this is a potentially a crime here, and a juror is going to sit there and say you didn't report, and me, Joe Juror, I'm going to say that I'm looking at this. And I think your conduct wasn't reasonable. I'm Joe Juror, and I think your conduct was unreasonable.
It doesn't use the term reasonable. It uses the term
I think your
necessary.
conduct was whatever. It fails to meet the standard. But I set the standard. It's who sets the standard. That's a critical issue. Does the prosecutor need to bring in cops on the stand to say, Officer Jones' standard, what Officer Jones' standard of care, what he did fell below the standard? In Senator West's proposal, he doesn't need to do that. He says, jurors, here's the facts. What do you think? You think that Officer Jones observed force that was excessive? If you do, then it's excessive. But under Senator Hedelman's, the prosecutor needs to bring in other officers on the stand and say, I'm Officer Smith. I've been practicing for 20 years. I've been trained, and what Officer Jones did was excessive, and this other guy should have realized that, and so they go to jail. But it's what evidence has to come on, and it's critical. It's critical to say from whose perspective do you look at this? Because I can sit here a Monday morning quarterback it forever without any experience, but if I have to, as a juror, say, let's hear what the experts have to say. Let's hear bring in 5 officers that are all going to testify that this guy used excessive force, and you sat there and watched it.
So what would your language be to say that?
It's exactly what Senator Hedelman read.
I guess my last thing is I just think it's I thought we needed to define excessive force. And I thought, if nothing else, that language is a good definition of excessive force.
Senator Bailey, and before we do, Senator Kelsey, you bring up a very important point. No, I understand. I understand.
Nobody paid attention when she read it last time. Everybody was talking, and people can be quiet and let her read it, and then we can hear what she said.
No, I got it.
No, that's not calling out a black
She sat right here and looked at me and said, "Is anybody listening?"
Oh my God! All right, let's go to Senator Bailey, and then we're going to go back. We have an open motion. Then we're going to have Senator Hedelman reread the language, and then we'll keep the discussion going. Senator Bailey.
Thank you, Mr. Chairman. Okay, so I would say that I agree with Senator Hedelman, and the reason is when we are talking about this and we're trying to develop a standard, we don't want to be able to look at an excessive force and blame the lowest ranking officer that actually did it. That's what the standard that Senator West has proposed. We would look at that one situation. But if we look at what Senator Hedelman did with the totality of all the officers, we could say, wait a minute, this is something that is wrong with that department. It's something wrong with the teaching. Then we could look at the whole totality of the situation. I think that's what we're trying to do here to start with. And I think that brings it so that we could then change the whole idea behind it.
Got it. Senator Hedelman, can you reread?
Sure. And again, this has to do with, this is from NCSL, and it's from the map that Jamie sent out. It's from Vermont. So this is applicable to, they use the use of deadly force. So I'll just read it as it's written rather than putting my spin on it. The use of deadly force is necessary when, given the totality of the circumstances, an objectively reasonable law enforcement officer in the same situation would conclude that there was no reasonable alternative to the use of deadly force that would prevent death or serious bodily injury to the officer or to another person.
Point. So the point that you like is that it uses from the officer's standard. I mean, look, I could go either way. I think the necessary language is fine, but I see what you're getting at is coming from the officer's standard of their policy. So, yeah, I see. Jeff, do you want to add something? You were making a point. Never mind. Well, I was thinking if there's a way to merge the two in that the necessary, I think, is correct, but you're saying from whether police, it needs to be from, all right, here's, I think, the point. It needs to be, I think that necessary language is correct, but it needs to be that it's necessary judging from the police what Senator Cassidy's saying, police standards or police objective, not from just what anyone thinks. So that, I think that if there's a way to merge the two, maybe I think that could fix it.
Read yours.
Senator West language now, and then we can just continue the discussion, okay? To build off of what you presented, and then we can keep this discussion going, because I think that's better than what we've got right now. Senator West.
I think that's a good idea, and then once we've done that, there may be a way to add this
what I'm saying.
objectively officer language into the
That's what I'm
standard.
saying.
But why don't we start with what I've got?
Yeah.
And then everyone is right.
Yeah, and then we're all right. All right.
All right.
All right.
Excessive force is force that exceeds what is necessary to gain compliance, comma, control a situation, and protect a law enforcement officer and others from harm.
The and is always kind of bothered me. Shouldn't it just be or? That's like saying and is like all those things. It should be
Yeah,
or.
could be or.
Or.
I don't care. Or is fine. Do it for. You like or?
So I understand the difference. I like West language. We just agreed the end should be or, not and,
Or is fine.
the final clause. I mean, actually, that standard you have makes it really hard because it has to be.
All three. I think you're right. I think or is better than and.
With that. Great. It's adopted. Now the discussion continues. Senator Castley.
So you would just simply take what Senator West read, and he says force that exceeds, and then we would slice in Senator Hellerman's language, which is something to the effect of force that exceeds that which is more than than a reasonable law enforcement officer. I'm sorry, I have to look at your language. Maybe you can propose an amendment, Senator Hellerman, based upon your language. But yeah, and just says force that exceeds, and then you insert right there.
The use of deadly force is necessary when, given the totality of the circumstances, an objectively reasonable law enforcement officer in the same situation would conclude that there was no reasonable alternative to the use of deadly force that would prevent death or serious bodily injury to the officer or to another person.
Discussion.
Do this on the fly, but
Here,
yes.
just type that out. Just borrow. So, can you read it one more time? Just the objectively reasonable law enforcement officer in the same.
Enforcement officer in the same situation would conclude that there was no reasonable alternative to the use of deadly force that would prevent death or.
Objectively reasonable law enforcement officer would conclude.
So let me.
It has to be objectively for law enforcement officer under the totality of the circumstances. Those two pieces are important.
I think you're muddying the water.
No,
I think what Chris gave first was fine. I think once we start talking to that all reasonable officer stuff, I think that's why we're here today trying to deal with this. Because what one officer thinks is reasonable against black folk versus what they think is reasonable against white.
No, that's not the standard. It's not whether, it's
Can I
not
say something?
a racial standard.
Yeah, can I just say something real quick?
But it's been different.
I remember having this discussion a lot over the interim, and I could never understand, because I felt like knocked me off of off base, but I thought that the reasonable officer standard was actually a higher standard, because you had specialized training and you're held to a higher standard from what you've been trained on. Whereas like the average person is the layman and doesn't have that level of sophistication and training in those situations. So I struggled with that, and I almost likened it like if you had a surgeon in a med mal, like you wouldn't hold Joe off of the street if they operated on you and removed the wrong organ. It's like it's the doctor has specialized training and is therefore held to a higher standard. I never understood the logical gap between that argument, and I still don't get it.
Well, you would bring in this case, like a medical, it'd be like a medical expert that comes in. So in a med mal case, he's got medical standards he's got to comply with. The jury's not going to understand what a law enforcement standard of the training is, but you'll have a law enforcement expert come in and say, no, you're not supposed to, once he's handcuffed or this or that, you're not supposed to have done this. So it'll be just like in a med mal case where you bring in the medical expert that says this is the medical standard, because the jury doesn't understand that. We don't know that you're not supposed to do this to the artery or whatever.
I mean, and that sounds very reasonable. And that logic that you put forth, it makes sense to me. But the reality seems to be very different from what we're living today. And it seems this standard that has been being used for whatever reason, a lot of officers who are slamming young girls in schools to the ground are getting off. Officers who are using pepper spray on a 13-year-old and asking and then complaining that they're acting like a child after they've been pepper sprayed while they're in the back of a car. I mean, these standards is not working. The whole reasonable officer standard. But again, the argument you make, it seems to make sense, but it's not for whatever reason, it's not working.
Well, that's why we changed the game, and you have a universal standards across the state that ups the level and then puts that training. So then you have clear, rules of the road and things that people have to be held accountable to, and then you have that level of accountability and sophistication. So I don't know. Senator Carter, then Senator Kessler.
I'll just remind the committee that the testimony at the bill hearing from Tim Maloney, who handles a lot of these cases, he specifically testified that the objective reasonableness standard is a standard that has been subject to interpretation, and more often than not, officers are found to have been operating objectively reasonable when other officers are assessing their behavior. Because that has been the standard from the Supreme Court and across the country for many years, it clearly has not been sufficient, because we are in the situation that we're in now with so many different states trying to up their use of force statutes and their use of force standards. And so I would argue that we should not readopt that same standard that, frankly, we already have under the law. I mean, I think it really serves to weaken our objective here. And I really do believe that staying with necessity is sufficient. If we go back down to objective reasonableness, I don't know that we accomplish a whole lot. I know that it's a sticky point for so many people here that really want to make sure that we are considering the plight of the officer's position, and the fact that they have to make these split-second decisions. But the standard that exists has been a failed standard. And if it were not a failed standard, I don't think that you'd have all these states grappling with trying to improve it, up the standard, including the federal, including Congress. So I'm going to ask us that we would stick with what Senator West offered and keep it moving.
So I've struggled with this, like the chairman, and I agree with the sponsor of the bill and Senator Sidnor that the current standard is not working. You have to ask yourself, what is not working about the current standard? And I think what's not working is the use of reasonableness instead of necessity. We're fixing that. And I also believe that juries are using the perspective of that particular officer in making determinations, and that's not appropriate. Because you could have an officer that genuinely fears for his life. He believes his life is threatened, but that fear is not objectively reasonable. And so the error is not whose perspective, because every state that has considered this, for the same reason that the chairman expressed, has rejected the idea that we go to a reasonable man standard, a reasonable person standard. The reasonable person standard is lower than the reasonable officer standard. The problem with the current standard is that juries are looking at this from the subjective reasonableness of the officer instead of the objective reasonableness. When you look at things from the perspective of that particular officer, then you're deferring to that person's individualized judgment. And I agree that is inappropriate, and it hurts our communities, and it hurts communities of color especially. But going to an objective standard where the determination is made from outside the mind of the officer, but nonetheless is made relative to what another officer who's similarly situated, as Senator Hedelman's language indicates, that is the appropriate standard. So I don't think adopting this does damage. In fact, I think it is much higher than the current standard.
So here's the language. Can you reread how you work it in? It's just the last sentence from Senator Hedelman.
So what I've got here is just that in this section, excessive force means physical force that an objectively reasonable law enforcement officer would find exceeds what is necessary to gain compliance, control of a situation, or protect the law enforcement officer or others from harm.
What about the similar situated language? Does it matter? Senator West.
I'm sorry?
Senator West, yep, your mic was on, sorry.
Well, I had taken Senator Hedelman's language and tried to interpolate it into what we agreed on a few minutes ago. So it comes out a little differently than Jamie's language, but
Let's hear it.
It would be, in this section, excessive force means force that exceeds what is, excuse me, let me go back. I missed my carrot. In this section, excessive force means force that, comma, from the totality of the circumstances, comma, an objectively reasonable law enforcement officer would conclude exceeds what is necessary to gain compliance, control a situation, or protect a law enforcement officer and others from harm. If we go that, I need to rewrite it because nobody's going to read my handwriting.
He didn't make a motion, but can we just remove?
You want to remove totality? Is that what you were saying?
Yeah, from Chris West's amendment, Senator West's amendment.
I can strike that out.
Can you just read it one more time then, without it?
Without that?
Yeah.
Makes it short.
Can I ask why? I think, I think it's
I mean, it's
important.
been seconded, so you roll it, you vote for it. I mean, I'm just asking a suggestion. I like the general concept. There's just like one or two words.
I think it's important to look at the totality.
super-
I mean,
Well, it just means totality just means you're taking account everything.
right.
Like, was the incident happening an incident happening in a public school might be different than an incident happening at a bar, right? You know, there's a totality of understanding. Was the guy high on some sort of like drugs that were like their fight back different, or like was the person elderly, or like, I don't know, there's a totality of circumstances. I don't think there's anything wrong with that word.
All right, shall I read it with the totality language? Yes? Okay. In this section, excessive force means force that, given the totality of the circumstances, an objectively reasonable law enforcement officer would conclude exceeds what is necessary to gain compliance, control a situation, or protect a law enforcement officer and others from harm.
Physical force, right?
Well, I only bring it up because of the conversation earlier.
Yeah. Did you say physical force or force?
I said force. I didn't try to define it.
So let me go back to that earlier conversation. So you guys say physical,
Let's see if we get consensus on this.
just physical force. You have to say physical because then it's,
What? What's the difference between physical and force?
as he explained, it's like when you get out of your car, that's force. When you speak and give a verbal command, that's force. Like there's a force continuum that they keep referring to. So
I mean, you think so? Well, what is your fear? I don't
just
know.
physical force. I don't know. It's fine.
He yelled at me more than was necessary.
Are
You yelled at me. You stood out.
Okay.
You stood out of the car.
All right,
You got out of the
all
car.
right. I mean, I guess I wouldn't see something. Maybe they would. All right, I'll concede that. That makes sense.
All right.
All right, Chris. Why don't we add in physical into yours?
Put physical in there?
We're
You're
good.
good with just force.
We're good.
He's saying that somebody could like go after you for saying you yell at somebody too much.
We, I think we're fine with Senator West's.
Doesn't that keep you wide open?
I don't think so. I
Okay.
mean, you're talking about the totality of the You're talking about the totality of the
just roll this
circumstance.
thing,
You
yeah?
guys are the attorneys. I mean,
Okay, this
look, we're talking about the totality of the
What's the shut off? The
circumstance.
TV?
So that narrows.
You gotta hold up. I can't turn mics off, I don't have any.
Oh. So
No, we're definitely not live. I don't know.
We're not live? We're not live?
So, Mr. Chairman, I think that stipulating the totality of the circumstance, takes out the broadness of it. I think it begins your articulation of the incident does the narrowing for you. I don't think we need to say physical force.
You think?
I do not think we need. Sure.
How much more do we have to do this?
I think you're good.
Where's she going? Oh, she's going back around. She's going back around.
So my intention in raising this other state's standard was not the reasonable law enforcement standard that I was interested in. I was actually most interested in the second part of it, was not posing an imminent threat of death to other people. And anyway, I am troubled by using the law enforcement officer standard in practice, similar to what Senator Sidner said. And in theory, I subscribe to what the chairman described, but in practice, it concerns me. So I would like to take that part out of what Senator West is. So a motion is seconded, but we were still crafting.
No, I was trying to figure out, because like that was literally the only piece that was different from your amendment than Senator West's amendment.
Well, it was framed slightly differently.
Yeah, which is I'm just trying to figure that out, because that was the only difference.
Well,
Substantive difference.
well, I mean, whatever. That's where I am now.
Okay. Senator Jackson.
I guess when information goes to a jury to make a decision, it's typically based upon some expertise, not just a witness, a victim, and a plaintiff. So where do you bring in the expert? Who knows who's actually been in that circumstance? So if you have a person who has committed a crime and you have a defense attorney who says, I believe Michael Jackson committed the crime, but I don't think that he knew what he was doing. And the way we're going to show that is we're going to bring in someone who understands what that means. You do it in, with it's a subject matter expert. Now, if the concern is, if the expert is coming from my agency, Mike Jackson got into a shooting, the case is before you, and I bring in my training officer from my agency, my training officer comes in from my agency, if that's the concern. But I think if we're going to expect a finder of fact to gain some sort of understanding, I think they need to have an expert. And the objectively reasonable officer piece means subject matter expert.
Thank you. We have jury instructions, and that's what would cover what the jury would consider if such a case were to get to a jury. So I can look up the language for that if you want to, but I don't think we write in statute. We write what we write in statute, and then we have a separate whole thing called the pattern jury instructions. That is what a jury is instructed to consider, which sometimes differs or condenses, or sometimes might expand upon what we say, what we put in statute.
Mr. Chairman, so the part that I saw that was different was the no reasonable alternative piece that I think is left out from what Senator West said. So that I saw that as a contrast to what was stated. So I just wanted to clarify that.
Yeah, I was just going to say, I don't see too much difference between necessary and no reasonable alternative, except that necessary is something that's plain and simple and anybody can understand, and no reasonable alternative means exploring all possible other alternatives, which a police officer under the circumstances just doesn't have the time to do. He has to act quickly. So he has to do what he's been taught is necessary, rather than evaluating a whole panoply of alternatives.
And I think the entire committee likes the necessary language. Everyone's good with that piece. But, okay.
Vice Chair Waldstraker,
Yes.
Senator Lee,
No.
Senator Castley,
Yes.
Senator Hedelman,
No.
Senator West,
Yes.
Senator Sidnor,
No.
Senator Jackson,
Yes.
Senator Bailey,
Yes.
Senator Carter,
No.
Senator Huff,
Yes.
Chairman Smith.
Yes.
Motion passes.
This piece now. Unreal. Okay, let's keep going. I'm sorry.
Maybe reporting comes next.
Did we finish reporting, did we?
Yeah, I thought we did. I thought we were just on this first part.
Yeah, yeah.
What was the?
Well, I think, aren't we done the first part?
Yeah, we finished the reporting piece.
We did?
Well, what we just did. Intervene.
Now we have duty to report. Oh, sorry, I'm sorry. I thought you meant the actual report that was going to be made. Sorry, yes, duty to report.
So, subsection C provides that a law enforcement officer shall report conduct of another officer to the reporting officer's supervisor or to the chief of a law enforcement agency that employs the reporting officer if the reporting officer has actual knowledge that the other officer has engaged in homicide, use of excessive force, a sexual crime, theft or a related crime, perjury, fraud or a related crime, tampering with or fabricating physical evidence. And that's the list.
Oh, I'm sorry. Thank you. Jamie, thank you. Senator Huff. Comments on this section? Senator Castley.
Comments, you're on section, which one? I'm sorry. On this whole 10803 in general? So I guess the only thing that I look at is we've got a general, we got two prescriptive sections there, and at some point there has to be the remedy, right? Whether it's jail or fine or whatever. And currently there's more of a catch-all in 10805, and I would just suggest that maybe we want to look at putting, having 10803 have its own remedies, whether that's fine or incarceration or what have you, rather than using a catch-all as we have currently with 10805.
I'm sorry. In the work group earlier, and that we had decided to move it, and we had decided to kind of make this parallel to what is currently in law for a penalty for a similar crime, right?
I agree. I think it ought to be with what's reporting that we have for like not reporting.
so-
We had this discussion, and I'm just bringing it up, I'm prompting it, but I agree with you. We had the discussion, and we thought it was more in line with like failure to report the sexual abuse that we addressed before in statute. So I agree, Senator Garner.
What is that?
I think it was a felony. We had that in for social workers, other people who have a duty of care to the children.
3-year penalty, which is similar to what already exists in law, where there's a duty to report.
So you're knocking 5 to 3 then? Is that what it is?
Yeah, I guess it's, yeah. Well, this has 5 or 10. We were
Well, there's
talking-
two. There's one is not exceeding 5 years, so that, it goes to 3.
One's recklessly and one's knowingly and willfully.
And then, well, what is, yeah, so if you go 5, you go 3 and the 1, what does the 10 become? Jill, do you know?
Huh?
Is it just all 3? What's the penalty? Because this has a, your bill has a 5 and a 10-year penalty.
We changed the duty to report penalty to a 3-year penalty.
So,
That's what we discussed earlier.
so everything is just 3 years, there's no 5 or 10 anymore.
Well, I'm not sure what we said about the duty to intervene, to be honest with you.
Language from the
I
statute.
don't remember. I don't think we reduced it to that. I don't remember.
Okay.
Ask Cassie or West.
All right.
Right. Do we have that?
That's already in the child abuse.
Right, so we just need to take the actual knowledge and the penalties, right. Does it provide for fines instead of jail?
Somebody's got to pull that
It'll
section
provide for
then,
fines and not
unless
just
they have.
incarceration.
Chris, do you have that section?
What section?
Do you have the section, does somebody have the section they're talking about, so we can look at the penalties for child abuse?
Jimmy, do you have
No, I
that?
don't have child abuse.
Do you have the child abuse penalties piece? Because it,
We need to pull that.
yeah, the failure to report, it's a knowingly and then plus a penalty.
Failure to report child abuse or neglect under 3602.2 is a $10,000 fine and 3 years or both, up to. Right, so the language leading in on that is may not knowingly fail to provide the required notice or make the required written report if the person has actual knowledge of the abuse or neglect.
Same standard and the same penalties into this provision. That's 10803.
I thought we discussed it earlier and I was good with it. Am I wrong?
Yes, you're right. That's what, you prompted me, you reminded me, and I know, you're right. We had discussed it, and we'd agreed to that.
So you're striking 1 and 2 and just making it 10,000 or 3 years. Is that what it is?
Yes.
Okay.
Have actual knowledge, but basically you're looking at just subsection C and what the penalty should be then?
So before we get on the, I know we're talking about the penalties, but when we talked about C, the law enforcement officer shall report the conduct of another law enforcement officer to the reporting law enforcement officer's supervisor or to the chief of the law enforcement office agency that employs the reporting law enforcement officer if the reporting law enforcement officer has actual knowledge that the other law enforcement officer has engaged in. Okay, here's the deal. If we're going to make a report, the officer should be able to make a report to any supervisor or the state's attorney or the attorney general. Because if he's making a report about, let's say, his supervisor, right, and he's going to make that report, he's going to jump the chain of command to do it. He's going to be himself or herself committing violations. If we are truly talking about somebody that we want to make a report, they should be able to make this report to any supervisor, or they should be able to make that report to the state's attorney or the attorney general.
So if we're going to do this correctly, from what I understand, you have to strike the current language in 10805 and substitute the language from the knowingly failing to report child abuse and take the 3-year penalty. So that's my understanding of what is being discussed. You strike all that's in there, and then you take the language of knowingly failing to report what's in child abuse, you make it a 3-year misdemeanor, 10,000 3-year. So that would be the new 10805.
Be part of 10803.
Okay, all right. Well, then that's what it is. Then you would strike 10805, that language. You take the child abuse knowingly part and you make it 3 years, 10,000.
Correct.
So I think to Senator, the issue that Senator Huff raised, right, I think to put that penalty provision in, you would have to separate out subsection C, and when you got to the penalties provision in 10805, you would just say, unless otherwise provided in this subtitle, and you would just have penalty provisions that applied to that reporting requirement. So that's technically just how I would do it if that was the issue you were raising.
Yeah, I think that's right. I think you gotta strike all this and just do language that's knowingly in the child abuse they said and make it 3 years. However you would draft that in, I don't.
And I guess is the $10,000 part of that also, or just the 3-year penalty? Okay.
Yeah, I would do 10 and 3. That's a standard. So the new one is going to be
$10, not 10 years.
yes, 10,000. And so what I would do is take. I don't have it in front of me. Does somebody actually have the child abuse? So strike all this, and then you put if an officer knowingly
Fails
to with this section, it's a 3-year or 10,000 fine or up to 3 years. All right, that's the motion.
Is that in place of?
I mean, they've got the child abuse one over there. They can read it. So
Just parallel to that.
yeah, I'm just cobbling together what they agreed to. So
What is the, so the time to report, what is that? It's not bookended.
Right.
as far as how long it can last for, well, it's a misdemeanor, so it'll be, I don't know, Jamie, what is it, like a year or something?
For misdemeanors, it's a year, but I think the question is over the reporting requirement itself. Right.
Wouldn't this
I'm
my
trying
bill
to
this
find
year?
exactly
I
in the
moved the
statute where it
statute.
says
This is my bill. I
immediately.
moved the statute of limitations on.
Right.
Yeah.
Notwithstanding any other provision of law, including any other law of privileged communications, each healthcare practitioner, police officer, educator, or human service worker who has reason to believe that a child has been subjected to abuse or neglect shall notify and shall immediately notify and give all information required by this section to the head of the institution or the designee of the head. So there is a timing requirement in that statute.
Adopted immediate.
Knowing, I think, and you have to have actual knowledge. I think we got to get that in.
Right, there's an actual knowledge requirement. Right, in subsection C, there is an actual knowledge requirement. For the criminal provision of the child abuse reporting, there is an actual knowledge requirement. In general, for mandated reporters, in order to be required to report, they would just need reason to believe that a child has been subjected to abuse or neglect. But in order to be held criminally liable,
Yeah. That's what they're talking about.
for the child abuse reporting, there needs to be actual knowledge.
Senator West. And then we're going to roll this.
I have something to talk about which is a little extraneous to what you're talking about right now, so I don't want to interrupt.
Does that language, if we just add it to 10803, because the requirements of 10803B are very different from C, do we have to have two different punitive sections, or how does that work, Jamie? Because one is talking about simply reporting, I'm sorry, one's talking about intervening, the other's talking about reporting. You section it out? Okay.
The committee does it. So if the committee makes the penalty applicable to everything in that section, which would include both.
That's not the intent. You're just trying to section it out because you only wanted to apply to this, to the report, not to the intervene.
Then what would the penalty be for the intervening? I guess it'd be the
It
next
would be
question.
the 5 and 10 for the rest of, that applies to the rest of the subtitle. Okay.
So did you all discuss penalties, if any, for the intervene?
No, we did not. We were focused on the reporting. Honestly, we didn't hit that piece.
Discuss actually the penalty, but Senator West and I were talking about it, and we were talking about the duty to intervene and the gravity of the situation, and we did agree that the penalty should kick in when there is serious...
Jill, I'm sorry, can you speak up? Because I really want to hear what you're saying. But
I'm sorry. I keep feeling like I'm talking loud. Seriously bodily harm or death.
Let's just do this real quick, just before, because I don't want to get anything jumbled up. So we're gonna bifurcate this because I don't think it was the intent to have this apply to the entire intervene and report. So for reporting, we're adopting this, which is before us, which I think everyone agreed upon. Okay, which is 3 years up to $10,000. I just want to make sure this is adopt that, and then I want to address Senator Bailey's point. We'll address it, move on, and then we can go back up to report. Okay, so is everyone okay with the penalty provision for duty to report? You have a question?
I wanted to talk about
Okay, sure, go ahead.
the penalty, and it's what Senator Carter was just talking about. So I gave two hypotheticals earlier. You have a guy who's hard to control, and the police control him and handcuff him. And then, alternatively, in the one case, the police kicks him in the leg, and in the second case, the police beats him to a pulp. So it struck us as wrong to subject someone who kicks him in the leg to up to 3 years in jail. It didn't strike us as wrong to someone who gets beaten to a pulp to have that kind of a jail term. So Senator Carter and I came up with the idea that the penalty would only kick in the event that the excessive force resulted in serious bodily injury or death. In other words, kicking him in the leg would not result in that kind of criminal penalty, but serious bodily injury or death would.
Fair enough. Okay, everyone's in agreement. So I don't know where you put that. That's for intervene.
That's just for intervene.
Yeah.
So you would have to make that part of the prohibition because a jury would need to find that.
Is that for report or intervene? Or both?
I'm sorry?
Or intervene or both?
I think we're just talking about intervening.
Got it.
It doesn't make much sense to apply it in the
report.
case of reporting.
He kicked me in the leg.
I guess it could.
So you need to make that an element of the offense, just because I think it's Apprendi says that the jury needs to make the determination on anything that
Yeah.
can affect the outcome of a
I think you're right. Right, it would be an element of the crime.
Right. I don't know, I guess on the intervening, just sort of logically, how that would work if they know that the other officer is using excessive force that's resulting in serious bodily injury, or would be likely to, that I think I can draft that, but I guess I'm not sure how they would know if the other officer, well, I guess they would have expressed an intent to do it. So, okay, I think I can work with that language.
Can I raise one issue? So based upon what we just talked about with the, in 10803B, I'd like to propose that under 10803C2, uses of excessive force, that we also qualify that that results in death or serious bodily injury. That way we're punishing serious excessive force. This is an issue that the state's attorneys had raised, that it's not really a defined crime with elements like the other matters listed here, but certainly someone would know, an officer would know that this excessive force resulted in serious bodily injury or death. So just to be consistent with B and C, that's my motion, that we added the qualifier that the use of excessive force results in serious bodily injury or death.
That's just for the reporting?
That's just for the reporting piece. Yeah, under C.
Shelley, see, all the other things listed have statutes attached to them, so they all have elements of crime.
And then we'll jump down to that real quick. So does everyone understand what we're doing? Yeah, read it one more time, yeah.
So a law enforcement officer who knows or reasonably should know that another law enforcement officer is using excessive force or has expressed an intent to use excessive force that is likely to cause serious bodily injury shall make a reasonable attempt to intervene, to terminate, or prevent the other law enforcement officer or officer's use of excessive force.
I think you gotta add death. Isn't it usually death or serious bodily injury? I mean, I get that death is a form of serious bodily, but usually they go together.
So is likely to cause death or serious bodily injury?
I'm going to roll it.
Vice Chair Waldstraker.
Sorry. Senator Cassidy, what's up?
I thought we'd amended intends to, has expressed an intent.
I believe it was to substitute intends to with has expressed an intent.
Okay, all right, just to make sure we're clear.
Is everyone okay with that? Do we need to roll it? Is everyone okay? All right. Everyone's good. So that passes. All right, now you wanted to go down to reporting.
Yes, the motion was on C, right below that C2. The use of excessive force, insert that results in death or serious bodily injury.
Senator Hellman.
Thank you. I guess I have a question, because it seems to me that there's a gap between serious bodily injury and does that mean beating somebody to a pulp? Is that serious bodily injury? Yes. But I don't know. I mean, it seems to me that there's something that's potentially a little bit milder than that you'd want somebody else to know about.
So there are a couple of different terms in the code, but serious bodily injury, the one that came up for me just now was in the transportation article, but it is defined as injury that creates substantial risk of death, causes serious permanent or serious protracted disfigurement, causes serious permanent or serious protracted loss of the function of any body part, organ, mental faculty, or causes serious permanent or serious protracted impairment of the function of any body part or organ.
So serious protracted. So if somebody broke my arm, I mean, that's not permanent. And is that protracted? And yet, I think that's excessive.
It's not.
Yeah, I think to give you a definitive answer, I'd have to find a case where a court said that it was. I'd have to get back to you on that.
Senator Sidler.
Thank you. I feel the change is unnecessary. We just earlier went through and voted on the definition of excessive force in 803A. We're not asking that they report force. We've already defined excessive force as force that some reasonable officer thinks it is. So I think to ensure that we're not finding that gap that Senator Heddleman is talking about, we have them report excessive force. Thank you.
So I also wanted to point out, there are, and the committee may decide that it wants to define the term, but there is also serious physical injury defined in the criminal law article, and that is physical injury that creates substantial risk of death or causes permanent or protracted serious disfigurement, loss of function of any bodily member or organ, or impairment of the function of any bodily member or organ. So it tracks pretty much with the other definition.
That's closer to what you're.
It's like a black eye with calling her that. You can't use your eye. I mean, that catches everything.
No, I mean that's closer for sure. Senator Carter.
Thank you, Mr. Chair. I want to be clear. I don't think it does catch everything. I think it catches the serious things, and I would liken it to under regular criminal law with the difference between a first-degree assault and a second-degree assault. I think that we're essentially taking out second-degree assault as a duty to report by doing this and saying something that's the equivalent of a first-degree assault. So that's how I interpret what we're doing.
So I fully appreciate Senator Sidner's point on this, that we're putting a reporting matter that comes in before you're darn near dead or beaten to a pulp. So I'd like to just amend the motion to use of excessive force that results in bodily injury and dumb it down. And the idea is just that the idea is that it's not, I mean, excessive force can mean that you just kind of jerk the person around. I mean, that's should get you a administrative punishment for jerking a prisoner around, but your fellow partner might not have that at the top of their head that, oh, I got to make a report on this because you jerked him around. But when it comes up on the video from the department, they'll say, wait a minute, you did not need to be rude to that guy and jerk him around like that. That was totally unnecessary, and we're gonna admonish you for that. But the partner will not go to jail for not reporting that. It may not have, in the totality. So I think just bodily injury.
All right, I'm going to seize this moment and let's just do this. We have a motion from Senator Castley, and it's been seconded by Senator Carter. So we are taking this and running with it. Is everyone okay? Good to go. Senator Castley, one more time. Senator Castley, just for the recording, can you one more time what the amendment is? What your amendment is?
On the reporting, it's just that it's on C2, use of excessive force that results in bodily injury.
You got it? All right. All right, let's keep moving. I'm trying to figure out.
So
Hold on. Sorry, that's right. Let's go back to this real quick. So Senator Bailey had the question about the reporting, the chain. Who do you have to report to? And so if your supervisor is the person, is the subject of your report, where do you go? So you suggested you could go to the Attorney General, State's Attorney. We're asking, who else? You got on the
So,
page 7.
yeah, I was going to say, I'm just going to tell you that this is one of the things that I actually lived, and if I'd have gone to the head of my agency, it wouldn't have mattered, all right? So the situation is that law enforcement officer should be able to go to his or her supervisor, and I think it should say, or any supervisor, the state's attorney, or the attorney general. right? State's attorney is the chief law enforcement officer in that county, should be able to walk in there and allege that this has happened and it is a crime, or contact the attorney general and do that.
I don't have a so there, oh my, the office of state prosecutor or state's attorney? He has state's attorney. You want to add this office of state prosecutor?
Isn't for badged officers, isn't the office of state prosecutor have jurisdiction? Misconduct.
They do have jurisdiction, public official. So you could add them.
So it can be the state prosecutor.
You could just add them.
It could be either or.
Yeah,
Right.
add
Yeah. All
office
or.
of state prosecutor as well.
Yep, that's fine. And I think I made a motion. Senator Carter
This
seconded.
we are striking lightning here, but before Senator Hedelman talks, I gotta get this. I gotta capture this moment. We have a motion from Senator Bailey, and it's been seconded by Senator Carter and Senator Hedelman. Go ahead. What's up?
Does that just, you're adding that to section 10803?
C.
Yes, subsection C.
Gotcha. Okay, good.
It's just adding the people that the officer
Yeah,
can
who
report.
you report to.
Yeah.
Go.
Senator West.
I have another proposed amendment, modest, but I think it's important.
Well, let's just go ahead and adopt this real quick.
Oh, okay, I'm sorry.
Yeah. All right. Yes, go ahead. Council's going to read it back.
Of another law enforcement officer to any supervisor of a law enforcement agency, a state's attorney, the attorney general, or the state prosecutor. If the reporting law enforcement officer has actual knowledge that the other law enforcement officer has engaged in any of those offenses. And I guess immediately, okay.
All right, Senator West.
That deals with my concern. I wondered about the word actual, so the use of the word actual is fine. Perfect.
Sorry, a second. You can take off camera for a second. Just writing.
Well, it is kind of hidden in the amendment, but not hidden, but just because of how it reprints on the next page after the one that we went over just now. There's 10804. That's the duty to provide or make reasonable efforts to obtain appropriate medical treatment. Just
So it's after, it's on the back end of page 7, so it's an unnumbered page, section 804, 10804. Did you guys talk about this one yet?
We reached. We're applying virgin territory here.
Thoughts?
In some other areas, we had talked about moving things from more towards the training side as opposed to, 10804 requires that you obtain medical treatment, and this is more appropriate for administrative sanctions than it is in this section of the law that's dealing more with criminal criminal restrictions, and it just seems to me that ought to be in the administrative side for, as opposed to this piece of the bill.
I actually kind of agree with that. It's just thinking about it morally. I mean, morally, we're making a crime for assaulting and use of force and things like that. And then this gets into you failed to do something good or you failed to do something right. So, I mean, I tend to agree. I don't know that this seems right to put into here, when this is really about excessive force and everything else, and now you're talking criminalizing they provided first aid or not. I mean, that's.
Thank you, Mr. Chairman. I'm certainly opposed to criminalizing, a lack of this effort. But look, I mean, in the oath of office that we take, we're to render that aid, and you're trained to render that aid and when the scene is safe. So, but I'm totally against the criminalization of it. And the rules and regulations say that.
Can I make a motion on this one? Okay.
So, I think 10804 in this standard that we are right here, I mean, did this for 30 years, is clearly your obligation and your duty. And you did it when you took the oath of office to protect everyone. And you were trained that way from day one. So the minute that something is de-escalated and someone is hurt, you have to provide medical treatment and medical care to them. I see no reason for 10804 in this bill.
You want it left in, or you want to take it out?
No, I'm going to strike it.
Mr. Chair, for exactly the same reasons that Senator Bailey just mentioned, I think it's critically important that we keep it in the bill. I won't go through the litany of cases. I brought up one earlier, and I bring up a lot, about Christopher Brown, the child in Baltimore County that was strangled by a law enforcement officer who chased him. He was an unarmed teenager. And it was very much believed that once the officer had caused Christopher Brown to stop breathing, that there was a real opportunity for him to render those life-saving skills that they are trained on and obligated to do. And had he done it, Christopher Brown might be alive. The same thing is true for so many others that are in a similar situation. And so I think that it's really important to keep this in the bill.
I agree. Definitely don't want to strike it from the bill. Senator Castley.
My motion, Mr. Chairman, is to move section 10804 from its current location and insert it on page 9 of the reprint, at the very end, as number, it says the last, line 28 is number 4, and it's 29 and 30. This would be number 5. And so it requires, put this piece on, that it's a required provision that they must develop policies and procedures for, and for which an officer could suffer administrative penalties if they don't comply with this.
I had two questions. One is, the implications here. One is that you're now removing it from the realm of potential criminal penalties. Two is just effective. Just in reality, don't most departments have this type of policy on the books anyway, or isn't this kind of I don't know. I'm just asking.
Yeah, I don't know.
It's in the law. I'm sorry, it's required that they render life-saving skills, and we're putting it's in policy. I think it's important that we put it in our use of force law.
And the policy call is whether you're going to, if you're going to provide criminal penalties for them not doing it.
Yes.
So that's what we're discussing right now.
Well, I think this is just one of the additional obligations, just like de-escalation is an obligation before using force. This is an obligation if someone's going to die and you can save them and you're trained to do so, you ought to do it.
Yeah, look, for the rest of the world, if I've injured you and I don't render aid, then you're going to sue me, you're going to get all your medical expenses, you're going to get probably punitive damages because I ignored you lying there. There's damages provisions for this, and it doesn't make any sense to me that we would treat law enforcement officers different than any other tortfeasor. If I've injured you, then I have because I did that, I have an obligation to mitigate your injuries, and if I don't, then there'll be a lawsuit. So in this particular case, I just don't see a reason to criminalize that which you can already make a recovery for, right? So,
The officer will lose their job for it. It's not like there's not a penalty. The officer will lose his job, too.
I think, really quickly, I think the frequency and with which this happens, and to be honest with you, some of what we're doing, not just in this bill, but in all of the bills, we're attempting, there's an aspect of it that is cultural change and behavior modification, and simply requiring that these life-saving skills that they are trained on be utilized in a case of life and death, to me, is a critically important aspect of this.
Yeah, but wait a second.
Especially when they're the ones that have created the life, the risk to the life.
This section does not say even a serious injury. Law enforcement shall promptly provide or make reasonable efforts to obtain appropriate medical treatment for a person injured as a result. This doesn't specify serious injury. This could be a scraped knee. This just says injury. This could be anything. A scraped knee, a bruise, it could be anything. This doesn't specify the level of injury. So now that anyone who has an injury, the person arrests him, they put him in the back of the car and they take him in, they go, well, he he's fighting the police officer the whole time, but yeah, he bruised his arm up or scraped his arm or, whatever. Separated his shoulder and you didn't know till you got him in, so you failed to provide it. Now instead of just being dealt with in disciplinary and the new Leobar board we set up, you got a criminal penalty.
Another reason why this is important is in circumstances that many of you are not familiar with and probably find it hard to believe, there are so many situations where persons are injured between the point of arrest and where they reach the destination, such as when they're transported to central booking or they're transported to any detention center. And it would seem to me that we would want to require an officer before putting someone in the cell, if they have caused an injury, to ensure that adequate medical attention is given. One thing we know is once the person is taken into the bookings place, they're really unlikely to get that treatment. It's just, to me, it's a common sense thing. It should be a part of the bill. That's all I got to say on it.
Thank you. So I'll go back to, thank you, Mr. Chairman. I'll go back to, the initial duty and the initial obligation of the officer. You are required to render first aid when the scene is secure, when necessary. And if that doesn't occur, then you can be charged administratively. We're talking about charging someone criminally, and as far as transporting an individual who's injured to a regional processing site, I'm not sure where that occurs, but you cannot drop off a prisoner that's bleeding or that's injured in any facet, because that then transfers from the officer who dropped off that defendant or that detainee. Now the onus is going to be on the regional processing site, and they're not going to accept that. So if a person is injured, it's happened a number of times. Those individuals are taken to either by ambulance, or they're taken by the officer to the hospital to render service. You cannot drop off an injured prisoner anywhere. I'm not sure where that goes. And again, I think what we're trying to do is to bring about accountability up and down the ladder, and accountability starts at the top. But everybody at every level has an accountability component here. Officers are trained annually into, I don't know what size agencies, I think every agency trains on the first aid component at least every 3 years to make sure you're up to speed on CPR and some other facets of it. But that is part of your duty, to make sure that once that scene is secure, if anyone is injured, you are to begin that aid and you are to call for medical assistance. Again, I want to reiterate, I'm not sure what entity in any criminal justice system that receives injured prisoners or detainees That is a serious accountability piece because officers can't just dump folks off. It's fine to keep the language in if you want to reiterate that, but I think the criminal penalties for such actions aren't warranted. I think administratively those are taken care of, but it goes back to accountability up and down the ladder.
But I'm struggling with the lack of a desire to have it included. And so I want to ask the people that don't think this should be in the bill. So if I'm arrested and an officer stomps my head and chokes me and I'm lying there on the ground, unable to breathe, and the officers are standing over me and they have an ability to render aid so that my life is not lost, you don't think the failure to do that when they caused me to be near death, and ultimately if they don't take action, I will die? You don't think that officer should be subject to criminal penalties if they caused the death the injury through excessive force, and then fail to render aid when they could save the life after they caused the injury?
Well, they'd already did.
And then I'm told, so then I keep hearing about the training. So I keep hearing they're trained on it. To me, that just means they can do it.
That's right. Okay. We have Vice Chair Wallstreicher, and then we're going to do Senator Castley, and then we're going to go to Senator Bailey.
So I agree 100% with Senator Carter, absolutely, in the hypo that she's offered. But I don't think the language reflects that now. So I just want to spitball on better creating language that mimics the circumstances where you want the penalty to apply. First of all, if we're going to have a penalty apply, we have to do it like we just did failure to report and duty to intervene. We've got to put it directly in this section, which we did with the other two. And secondly, I think we have to reverse the wording. So you use the phrase failure to render aid, which I think is exactly the right idea. And so this is phrased in the affirmative. But I think if you're going to provide a criminal penalty, it will read more clearly to include the behavior you're talking about, to phrase it in the negative. And so here's how that would read. A law enforcement officer may not knowingly and willfully refuse to promptly provide or make reasonable efforts to obtain appropriate medical treatment for a person with a serious bodily injury, or for a person who sustains a serious bodily injury as a result of a law enforcement officer's use of force. I think that more clearly gets at the behavior you're looking for without being over-inclusive and requiring an affirmative duty that is beyond the behavior you want to criminalize. I don't know if I can do it a second time. I'll try. All right. A law enforcement officer may not knowingly and willfully refuse to promptly provide or make reasonable efforts to obtain appropriate medical treatment for a person who sustains a serious bodily injury as a result of a law enforcement officer's use of force. And then, as I said earlier, you have to put the penalty in 10804, as we did with 10803 for each of those sections. You have to put it directly there, if you do that.
From what I heard, that takes out the responsibility to provide medical care promptly, right? You took out promptly.
No, the only qualifier he put it was a serious injury, serious bodily injury. So the smaller, as to Senator Huff's point, the smaller, more not trivial, but the smaller knee scrapes, things like that, you would not have criminal penalties. You would not be subject to criminal penalties if you didn't render immediate aid. That's the only qualifier he puts on.
The only thing I'll say is, in our law, we have varying degrees of assault, and I know that there are many a person that get arrested for an assault that doesn't even result in any injury, any physical injury at all. It happens all the time. And so I just think it's a little bit hypocritical and a double standard to say, well, if the injury isn't life-threatening or really serious, it shouldn't count. I think it really should count. And so I think we went to injury before. We went to the injury standard on Senator Cassidy's amendment, so I would make a motion that we would use injury here and not serious life-threatening injury.
No, I get what you're saying. But it gets you closer. All right, go ahead, Senator Cassidy.
The officer is still liable for the assault. If his conduct was not warranted, he's still liable for an assault and battery. He's just like any other potential defendant. But no other potential defendant in this state would have any liability if they didn't render first aid, other than in the civil law. If you don't go to, if there's a fight, there's not a separate offense to say, and after he hit him and he fell down and hurt himself badly, he didn't render aid. You could get a lawsuit for that, a civil lawsuit, which is what I proposed on this. So this is substantially more of a challenge for a law enforcement officer, which is why the proposal is, since you're upping the ante on a law enforcement officer, let's kind of skip up to the more serious stuff. And I think it's entirely appropriate.
So I'm going to go ahead and jump in here. Okay, I mean, having your light lit and watching people go around the room is one thing, but, okay. And came back to this point about 10804 and why there is issues with this. And let's bring it back to real life about the fact that we are chasing an individual, let's say down an alley, through a field, whatever. That individual has a heart attack. All right? He's sitting there right in front of us, cardiac arrest. Now, are officers trained in CPR? Absolutely. That person hits the ground, but if I have no protective gear whatsoever to protect me from any of the communicable diseases that exist, I'm under no obligation to give that person CPR without protective gear, right? The same would exist if I did not have the protective gear associated with being able to put gloves on, to be able to protect myself from any type of blood spray or spatter. Why am I going to be held liable if I didn't have any of those things? Right? This is very important if we are going to put into something like this a criminal penalty for failing to act. Now, if that officer simply has the ability to get to a phone and call it in, back when I started, we were all EMTs. We all rode in the back of ambulances. And the fact was, if somebody was hurt, we were able to help them. But then, that was long before AIDS, tell my age here. But after that, and it started, then the standard of care switched around. And you didn't, as a trained medic, you didn't have to perform. And I don't think that the fact is, if you are doing something and you're not right with your car, you don't have a medical kit, you can't get out to go chase a felon down the street and carry a backpack with all your medical gear with you. That is not reasonable. This should be in a policy and procedures issue. And clearly, an officer has a fiduciary responsibility immediately to try to help someone. Now, that help could be standing there in the scene, keeping the scene safe, calling and having an ambulance coming as soon as possible, right? It could be talking that person through, hey, you need to put pressure on where you are bleeding from. We have to stop that pressure. It does not mean that that officer has to risk his or her own life and put their hands in that person's blood to try to stop that bleeding. And that is what a standard that we are looking at here that is just more than what I think that we intended.
Okay. I like the, so I think, thank you very much for that. I think the Vice Chair's amendment or suggested amendment is actually a pretty elegant solution. And if you're going to push it, I'll second it. But just to, so to address your concern, this section does not apply to a law enforcement officer if, under the totality of the circumstances, a reasonable law enforcement officer would believe providing or obtaining medical treatment would be unsafe. I think that could cover a lot of what you were talking about, and that's still in here. So let's, do you want to?
Sure, I'll make the motion.
Okay, second your amendment. It's been seconded. Did you have something to say? Okay. Senator Hart.
We're talking about his language with the serious thing, so I'm not going to support that amendment unless it's just regarding any injury. I just want to say that when someone is taken into custody,
No, go ahead.
What are you saying? Oh, I'm sorry, the other motions, I thought it was directed at me. I was like, damn, I just started. You haven't even heard what I was going to say yet. So when I'm taken into custody, I'm helpless. I'm at the mercy of the people that have arrested me, and I become their responsibility. They ought to be responsible for rendering aid if they injure me in the process, period, whether it's life and death or not. So I'm going to ask to reject Jeff's amendment to the extent that it limits to those most extreme of circumstances where death could occur. I just think that aid should be rendered even in something short of death or near death.
What is your definition of aid?
It's
Where is a trigger for the police to get involved? Maybe the police get involved.
All right, we'll read it one more time and then we roll it, okay? Okay, sorry, give me a second.
You want me to write it? Okay.
Can you clarify?
All right, here we go.
So, a law enforcement officer may not knowingly and willfully refuse to promptly provide or make reasonable efforts to obtain appropriate medical treatment for a person who sustains a serious bodily injury as a result of the law enforcement officer's use of force. Use of force.
Use of force. And that's the law enforcement officer who caused that, right?
Correct.
Who's the cause of that?
Sorry, Senator. So the new language would be a law enforcement officer may not knowingly and willfully refuse to promptly provide or make reasonable efforts to obtain appropriate medical treatment for a person who sustains a serious bodily injury as a result of the law enforcement officer's use of force.
Senator Lee,
So there is that connection now, right?
what's your question, Senator Lee? Sorry.
I think you answered it. There's that proximate cause, right? By the officer caused it.
Yes, yeah. Senator,
It could be, so as a result of a law enforcement officer's use of force, so
any other law? Anyone on the scene? If he's,
I guess depending on which article it is, either a or the, could make a difference.
they're all doing there. Senator Carter.
Awful continuing to go over and over this one little section, but I just really feel like I don't understand the need to backdoor this thing. What is the problem with requiring the prompt aid, must do it promptly? I think in other parts of this bill, we've said, why are we speaking in the negative about what what would happen if you don't do this or what you shouldn't do? What is the reason that we need to say may not refuse? Just say that they shall give prompt aid. Again, we're talking about people that are in their custody, people that don't have any ability to get any aid for themselves. They can't do anything. They're completely at the mercy. What is the problem with requiring that they got to promptly do something about it? I don't understand.
Probably do something. It's whether you throw them in jail or you demote them. Oh, I know, because they're cops. We should throw them all in jail.
No, you should throw them in jail because they caused an injury and they make it worse and exacerbate it by not getting the person help.
Senator West had a question.
And not a question, really a comment. I really think this should be the subject of its own bill. This is both under-inclusive and over-inclusive. We talked about the guy who was running away from the policeman and had a heart attack. This bill wouldn't cover him. The policeman could just watch him die based on this bill because it wasn't as a result of force. So it's under-inclusive in that respect. I think it's over-inclusive in subjecting policemen to criminal penalties which are undifferentiated. So a scrape on the one hand or a heart attack or whatever on the other engender the same criminal penalties. So this is under-thought out. It was originally like 5 lines in the bill. It ought to be its own separate bill, which is well thought out and well constructed so that we can defend it on the floor. And so that it'll be good law once it's enacted.
All right, duly noted. So we've had a motion and a second. Just going to run it, see what happens.
Vice Chair Waldstreicher.
Yes?
Senator Lee.
Can you come back to me?
Senator Castley.
No.
Senator Hedelman.
Yes.
Senator West.
Pass.
Senator Sidnor.
No.
Senator Jackson.
No.
Senator Bailey.
No.
Senator Carter.
No.
Senator Huff.
No.
Senator Lee.
No.
Senator West.
No.
Chairman Smith.
I'm riding with the vice chair. I thought it was a good compromise. There's halfway. I said yes. The amendment fails.
I got an amendment.
It was all right. Senator Huff has an amendment.
Strike that section in its entirety.
So you're not even moving it over to the to Senator Castley's suggestion from before, just as an administrative piece. Is that your suggestion, or you're just going to strike it?
It's already. If you don't need to move it to it's already administrative penalty not to do this stuff.
Not uniformly, but yes. Not in state law, but policy across the state. Potentially. I don't know. I haven't looked into the.
All right. Well, all right, look, I'll amend my amendment. I'm happy to, if Senator Castley wants to reoffer his moving it to administrative penalty, I'm happy to entertain that.
I'll make that motion again. So I move that we take that section and move it under, it's page 9 of the bill, 9 of the reprint, right after line 30, which would be a new 5. And so what this would do would be require all of the jurisdictions to develop policies that required this provision and provide for follow-up, and that way it could be enforced as an administrative penalty. So that's my motion.
All right, everyone understands, it's no longer criminal penalties, it's going to be administrative, and it's been seconded, so let's roll and see what happens. Roll call. Jamie's got to reread.
So the amendment would be to move it from 10804 and work it back into, right, page 9 of the reprint, but that would be under 3523 on, that starts on page 8. So that's for each local law enforcement agency to establish, maintain, and implement policies and guidance for law enforcement agencies on, and this, I suppose, would be something to the effect of promptly providing or making reasonable efforts to obtain appropriate medical treatment for a person injured as a result of a law enforcement officer's use of force.
Got it. All right, roll it.
Actually, that's exactly.
Vice Chair Waldstraker.
Yes.
Senator Lee.
No.
Senator Castley.
Yes.
Senator Heddleman.
No.
Senator West.
Yes.
Senator Sidnor.
Nope.
Senator Jackson.
Yes.
Senator Bailey.
Yes.
Senator Carter.
No.
Senator Huff.
Yes.
It passes. Chairman Smith.
I'll go no. I thought the compromise before was better for the serious bodily injury. You see how things play, right? See how things shake out. Okay.
Or we could have just left it alone.
The amendments are made. It's the committee's will. Everyone's got one vote. All right. Let's keep moving. Senator West.
It's getting late. Some of us are hungry. I've got a suggestion that could conclude our work earlier than otherwise might be the case. So we just spent an hour defining the term excessive force. On page 6 of 11 is the key substantive provision in the whole first part of the bill, which says a law enforcement officer may use force only, yada, 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 yada. And it uses all these terms which are defined all over the rest of the first part of the bill. Why don't we change that to provide a law enforcement officer may not use excessive force, and use the same definition of excessive force as we hammered out an hour ago?
I'm sorry, Senator West. I didn't catch.
Didn't lose all the
I heard the
modulating.
last part, but what were you saying to strike?
6 of 11, at the top of the page in section 10802A, currently it states a law enforcement officer may use force only, and then sort of it tries to define excessive force with hearkening back to lots of other pre-definitions in the previous pages. So strike that provision and replace it with a statement, a law enforcement officer may not use excessive force, and just use the same definition of excessive force that we spent an hour developing a few minutes ago?
Well, I actually think some of these things are really informative and instructional, and I think that they're incredibly important factors.
But
to
why would we
consider.
want to have two separate definitions of
I
excessive
don't.
force?
So I don't really want to. I'm kind of having buyer's remorse on the last one. But because your definition was somewhat general, and it actually included the potential for an officer to use force when there's no real threat, because I think that the amendment that we passed had something to do with, abating a situation. It may not have even been a forceful situation. I think these specific criteria are important. Now, I agree with you. There may not be parity in the bill anymore because of that, but I think that this bill has to have someplace in it these things spelled out.
I see, I just don't understand. The definition of excessive force that we adopted before was, we all agreed on, and it was quite clear. Why in the world would we want to spend what undoubtedly will become hours more this evening trying to hammer out a different definition of excessive force on pages 1 through 6 than the one we adopted on page 7?
Well, because people of the state of Maryland are depending on us to come up with the best product, and trust me, I don't want to be here anymore. I probably want to be here the least of everyone, and I know how will say, well, it's your bill. But I think it's critically important that we get it right. And I honestly have serious concerns about what we just limited to. You said it fast, and I was thinking, and I was trying to be, work quickly through this, but I actually think these things are necessary to spell out. I do. So, I'm happy to hear from other people. If you don't think they are, then fine. But a part of this was to clearly delineate what we think, not what we think, but what we want officers to do, how we want them to act in these situations, when we want them to use force, when we want them to use alternatives. We want to give that type of instruction. We don't want to leave it up to so much, chance as what it's been, because we're here because there's been a lot of problems with the current situation. So I think these specifics actually matter, but I won't belabor it. If you all don't think so, that's fine. Very rarely are we in agreement on these things, but I think that we should not take these out of the bill.
And I'll let other people.
So I appreciate what Senator Carter's saying, but what we've been doing is looking at an entire array. There have been problems. I guess nobody's going to dispute that there's always problems, and we're never good enough for what we do. But we've engaged in numerous changes that this committee has approved in the interest of police accountability, police responsibility, both administrative remedies and criminal remedies and civil remedies. And I find that the first part of this bill that we're now proposing to go through is really counterproductive, because what it's going to do is try to make us the micromanagers of every little police action, and that's not what we want to be doing here. We want to set up, we've got this Training Standards Commission, we have all these elaborate requirements now, we have bodies, we've changed the processes by which we're going to adjudicate law enforcement officers, and now the beginning of this bill, instead of just simply saying police officers can't use excessive force, we're gonna go into this in excruciating detail that's just inappropriate for a legislative body. That's why we established a Maryland Police Training Standards Commission to go through this stuff and figure out exactly how you how you deal with every little situation ad nauseum. So I fully support Senator West's motion on this. Thank you.
Yeah, I was just going to say, I mean, the main point of this is to deal with excessive use of force, which we're doing. We're creating a penalty. I think that's a huge step forward. I mean, we dealt with the same kind of issue with body cameras, and that was the bill that we dealt with this year. We saw the rehash of that from a couple years ago. Originally, the bill spelled out all of this explicitly. When police would turn it on, when they would turn it off, it had us completely micromanaging and dealing with it. And after like a month of session going back and forth on this bill, we finally said, this is really the Maryland Police Training Commission that has to deal with all this. We're not going to put it in statute. We're not going to put it in law. So I would just agree, everything that says reasonable. The bill's dealing with excessive force. We can't with a standard. We should just restate that and move forward and not get into the we don't. In the past, we've never got into this kind of micromanaging. We've let the Maryland Police Training Commission do that. And quite frankly, we did police reform a few years ago. That's why we made the Police Training Commission, we made them independent. We totally changed up that body. We did a lot of things to put trust in them to come up with these standards.
So I again find myself with Senator Carter on the language that we have here being good language, and that we want officers to try verbal persuasion, and we want officers to try waiting out a suspect, and we want officers to allow a person to move about if it is safe to do so. The question is about, for me, is not whether this language is appropriate. It's perfectly appropriate. The question is whether we want to attach criminal penalties to this language, which under its current setting attaches criminal penalties. So if an officer does not use verbal persuasion, that officer can go to jail. And if an officer doesn't try waiting out a suspect, that officer can go to jail. If an officer does not allow a person to move about if it is safe to do so, or to ask questions or make statements, that officer can go to jail. So I think all of this is really good language. And I think it's the type of stuff we need to move towards as we reimagine policing and try to provide a more of a kind of guardian mentality instead of a warrior mentality. For me, it's just that to attach criminal penalties because someone doesn't do all of these things is not appropriate. So I hope we can find a solution that allows us to retain so much of the values behind this language, the value of de-escalation, the value of not rolling up on a scene and kind of coming in guns blazing, but not criminalize an officer who might be trained in the old ways or otherwise doesn't take all of the steps listed in this subsection.
I know that I'm not the brightest light, but I don't believe that the bill currently criminalizes each and every one of these things. I believe that the bill lists these things as factors in determination whether or not the officer used appropriate force. And so for those reasons, I don't agree that we're going to criminalize someone for each and every little thing in the bill. I don't think that's the plan. I think these are factors to be considered in the overall decision that they made to use force and how they used it. And if there's a better way or place to put this, then fine, but I definitely would take strong objection to removing these factors from the bill.
No, I agree. I guess the second question then is, since you're not looking to necessarily criminalize the failure to adhere to one or two of the elements, then my question is, was this language adopted from or modeled off of like policy or statute found somewhere else? Because if it's policy, then, you know, I agree you have to keep this language in, but then you go for like kind of in your tiered kind of system of preference, then the second tier would be you just have it is you make sure that it's something that everyone is trained on, and that the respect, and that every respective of law enforcement agency would have to adopt a policy. And I know that's a kind of the second tier solution, but if you're not looking to criminalize the failure to adhere to one or two or any of these elements, then that's kind of the next best solution that I can even think of. You do that, then you drop Senator West's language in there defining what excessive force is in, and then call it a night. That's the second best thing I can think of. What are your thoughts?
So, and I've been completely unsuccessful on every single thing that I've tried to do. So I'm not going to assume that I'll be successful here.
That's not true. It's not true.
Okay? It's true.
We said it for the first hour and a half. It was a consensus building process. You know, you had different people ride with you on certain things, but you know. So what's the committee's will on that? Senator Hedelman.
For clarification, so you're talking about the definitions and then the de-escalation techniques. Is your suggestion to ask? So my question is, can you explain more fully what you're proposing? Are you saying to take basically up to through page 6 and have each law enforcement entity create a policy around the use of force, and then penalty-wise, then it goes from there? That you have penalties for engaging in excessive.
Yeah, I mean, if you heard the line of argument that was just discussed a little earlier, that if you failed to adhere to one or any of these elements, that you'd be slapped with a criminal penalty, and you want to maintain kind of these standards without the criminalization, then it's a development of policy that every law enforcement agency have to do.
This is a statewide policy.
Correct. I mean, but each agency would be responsible for. There's less micromanaging than you think. I mean, the Police Training Standards Commission would set the floor of, hey, you've got to train on all this stuff. The departments then go forward and develop their policies based on the floor that the Police Training Standards Commission has set. You do that, and then you drop in Senator West's language for what excessive force is, and then you have. This is not I'm just telling you what the option is, and then you would have a bill that is more in sync with itself, and you wouldn't have criminalized these elements. So I'm not, just putting it out there. That's the second best. I mean, I know what Senator Carter's aim is, but I'm just trying to put something out there that maybe there's consensus around. Okay. Senator Jackson, and then Senator West.
Thank you, Mr. Chairman. Look, I agree with the fact that, we're talking about policy and procedure, and I think if we want to be uniform, we've all talked about what are we going to do as a state. How do you ensure that 150-plus agencies adhere to it? We created in 2016 the Maryland Police Training and Standards Commission. That's their job. That's their job. And if you take a look a few years back, and you'll see it in the public safety article because we've already heard the bill, but everything that we talked about in HB 1016, the Maryland Police Training and Standards Commission had to put into motion. And they did that by forming committees within the Training and Standards Commission, which has civilians, which has legislators, which has the AG, which has the ASAC for the FBI, which has, police and chiefs and sheriffs there, and FOP members. And that group came up with that information that the bill specified. We do the same thing here. They will adhere to what we put in here. And every agency will have to adhere to that. And as mentioned earlier today, it goes out for public view. So I think it makes sense. You get rid of the criminal penalties. You put it in place as part of policies and procedures for the agencies, is where it belongs. And also, instead of having to come back here every 9 months to make the adjustments, the Training and Standards Commission makes the necessary adjustments, that we deem fit.
All right. Yeah. Thank you for that, Senator Jackson. Again, I was wondering if anyone knows this. I think we did research on this before, like for where the language may have come from. Was it from a policy or a statute? That's what I want to know. If anyone actually move forward with criminalizing these things, or was it a policy? I think it was from Camden, New Jersey. I don't. Is it a policy or is it a stat? Was it? Do you remember?
Policy
If you can.
Yeah, I'd have to pull up the language, Mr. Chairman, but I can get back to you more definitively.
Got it. Senator West.
Thank you, Mr. Chair, and I'd be pleased to withdraw my motion and second your proposal.
I'm just putting it out there. It's not my proposal, but Senator Sidnor and then Senator Heddleman.
Thank you. If I might ask Senator Jackson, I know last week during the discussions of one of our other bills, he had introduced some amendments, and one given the Police Training and Standards Commission some real regulatory teeth. And if we're going to continue pushing things down to policy, I think it would be wise to revisit what he was attempting to do last week, and I'm just curious to know whether or not, or where you are with that language, if there's been any progress been made.
Well, I appreciate that notion because I was trying to find out how we could actually circle back to making them the regulatory commission. I think the challenge with the amendment that was submitted last Monday dealt with there was some language that needed to be stricken from that amendment, but it makes sense. We're pushing toward policy. We created that body. We separated it from the training, the normal training piece, and they should be the regulatory body. I agree. So, Jamie, I guess we can work on what needs to be stricken from that.
So then
It's
another
the
alternative.
it's a chair, so it's so inclined.
Look, like I said, I'm just putting things out there for discussion. Senator Heddleman, and then I got maybe another idea.
Thank you, Mr. Chairman. I guess I'm not satisfied by ceding which I think is our authority to make these decisions. I mean, the use of force is a policy call, and I think that it is pretty, that the definitions here and the continuum is spelled out here, and I think that if we go down the route of giving them more power to come up with a policy, that these pieces should be very clearly articulated in that, and that we should be giving them direction to do that and to follow this. So I think it could be and in both. It could be that we use what is here and have them create this floor, but I would hate to throw this out.
I agree, and you know how we ensure that? We have 4 legislators that sit on that body.
I think it should be part of the statute.
Oh, I guess I misheard you. Sorry. Is there a motion on the floor for the?
Develop policy around this.
Mr. Chair, did you make a motion, or I can make the motion?
I didn't make a motion. I was, like I said, I just put the idea out there.
I'll make the motion.
Another. Just as.
Sorry, he made the motion. I second. I just want that.
It's
Okay,
not a
I got it.
motion.
I got it.
You didn't put a
Another-
motion out there.
There's a motion and a second, right?
It's a motion second. It's open for debate. So, another idea, Senator Carter, I'm asking. What if you were to keep the language as is, but it's not it's got to be like a summation of all of them. It's got to be like not just one or the other. It's got to be like all of these things together create. I'm not sure if that works, but
That's not a motion, that's a suggestion.
yeah, I'm just tossing another idea.
I thought the prior idea was an idea, not a motion too.
Yeah, they're both ideas.
No, Michael
But-
Jackson made the motion. I seconded it.
Senator, so whose amendment is it then?
Michael Jackson's amendment now.
What
Okay.
is the amendment?
The amendment is to take it all.
PTSC, and ensure that every agency in the state adheres to this policy, to these policies. That's the motion.
So we'd have to move to a different part of this bill, but it would.
Senator Carter, what do you think about my second thing? I just want to.
The second suggestion, where these so I think that's more in line with my thinking, that these are factors to be considered in determining whether or not there was a violation of force or excessive force. And so I think that makes sense. I think that the committee has repeatedly interpreted this as each little thing is a crime in and of itself, which I find kind of astounding, because every single crime we have in the criminal statute has elements of a crime that are factors to be considered, and all these things together, if they're done, they result in a crime. So only here am I seeing, like, where we think every little thing in and of itself is a crime. I don't think I've even ever seen that in the code anyplace. So I think that second one sounds more in line with what would work. Like Senator Hellman, I have grave concerns about taking this and reducing it to something that is policy that the Training Commission oversees. I think that we should be clear about we are deciding how we're going to govern the use of force in the state. That should be us, not them.
Senator Jackson, go ahead.
Thank you, Mr. Chairman, and I appreciate your sentiment, but we created the Maryland Police Training and Standards Commission. We did that in response to the Freddie Gray incident. We created that. We took that away because we said it wasn't working, and that's their job. They adhere to every directive we gave them in HB 1016, and so they will adhere to every directive we give them tonight, or from this circumstance. But that's why they were created. There's no other reason they were created. So I say give them this piece and let them come up with a uniformed statewide policy that everyone has to adhere to. And we hold them accountable because we have 4 people sitting there before these before each step gets enacted. It has to be published. It has to be agreed upon by the 24 members of the commission, which includes 4 of us and 4 civilians and a host of other folks. It's my suggestion. It's my amendment, actually.
Yes, thank you, Mr. President. I think there's an easy way to do this. You'd simply start section 10-801 on page 3 with the following sentence. The Maryland Police Training and Standards Commission is directed to incorporate the following definitions into its statewide policies and guidance for law enforcement agencies, : then you'd have A, there's the definition for de-escalation tactics; B, the definition for imminent threat; C, the definition for lethal force; D, the definition for necessary force; E, the definition for reasonable alternatives; and F, the definition for totality of the circumstances. And I don't believe I would want to spend time trying to redefine these terms. I think the definitions provided are fine. So that would be it. And then that would take care of the first 3 substantive pages. And then on page 4, we could do what I suggested earlier, which says a law enforcement officer may not use excessive force, and simply incorporate the definition of excessive force that we adopted an hour and a half ago now.
So the factor-based option that I presented, I'm looking around the room. Does there seem to be support for that? I'm looking around. Looking for a friend. Okay, so that would keep this in. All right, no one's, okay. All right, so then that is not an amendment that I'm willing to make. All right. So Senator Jackson, do you withdraw your amendment?
I think
Okay.
I think we get where we need to get with what Senator West says, and we have directed MPTC.
Okay, so
TSC.
can we just, so we understand what we're discussing, can you just say it one last time?
Surely. So on page 3 of 11, at the beginning of section 10-801, we insert the sentence, "The Maryland Police Training and Standards Commission is directed to incorporate the following definitions into its statewide policies and guidance for law enforcement agencies, : and then you take the key definitions in this section and make them subparts A, B, C, etc. So it'd be A, de-escalation tactics and techniques, B, imminent threat, C, lethal force, D, necessary force, E, reasonable alternatives, and F, totality of the circumstances. Yes, okay. The second piece was you replace section 10-802 with the following, with one sentence: a law enforcement officer may not use excessive force, and then you simply put into this the definition of excessive force that we created a while ago.
Is it seconded?
Yep, second.
Sure.
Chris, would you leave, so you would delete the rest of 10-802, I'm sorry, you would delete the rest of 10-802, insert the language you just said. What would be, then look on page 7 at the top, would you be leaving in C?
Frankly, I haven't paid attention to the section on lethal force. That would be something separate. I was looking at 10-802A.
Well, I thought you were doing all of 10-802, inserting that as all of 10-802.
No, I was
still
inserting it
have
in
to
the
go
part
to
of
all the-
802 which tries to get to address excessive force. But the 802B deals with lethal force, and I really hadn't focused on that.
Well, excessive force, lethal force is excessive. I mean, it's just the ultimate lethal force, right? I'm sorry, lethal force is the ultimate excessive force.
Yep.
Senator
So-
Walstreicher.
Yeah, so eventually, we can't adopt it in whole, because the lethal force includes things that are not, in fact, lethal force. So, a kick to a person's head is not inherently lethal force. The use of an energy weapon is not lethal force. The discharge of a projectile launcher, in other words, a beanbag, is not lethal force. So, eventually, we have to come back to this.
Why can't we just delete all of that? Okay, I mean, if you want to. I don't understand why you would keep anything in 10-802 other than what Senator West just proffered.
I think Senator Kansley is right. If we've defined excessive force and we've criminalized excessive force, then lethal force that is excessive would be criminalized. Lethal force that is not excessive, like, protecting yourself if somebody draws a gun and points it at you, would be okay.
Out B and C as well?
Frankly, I hadn't thought. but lethal force.
I hear
is
you,
just, if
but I,
you know, lethal force that's justified is okay, lethal force that's not, it's excessive. And that's criminalized in here.
So you could make C say. Law enforcement who uses force against a person that results in death is that, and then number 2 would be excessive force. Both just take lethal force and substitute excessive force in C 1 and 2. You see that, Chris? Law enforcement who has.
Yes. I think you'd have to spend a little time on it. This talks about reckless endangerment and assault. G.
Amendment as is makes sense. I think we should just roll it and see where we're at. I mean, his
we
amendment right
don't
now.
know where it is. Yeah,
Well, Chris can explain it again.
I think he's not,
He's not going to deal with that
Included.
section. Just
Where
get
it
rid
is.
of it.
Chris, would you be okay with changing on C? Just change the language under C to say excessive force and strike legal force. Go with excessive force.
Let's read C.
C1 and
A
2.
law enforcement officer who uses excessive force against a person in a manner inconsistent with this section, are we going to delete that results in death? No, you have to, because
Yeah.
the penalty is manslaughter or murder.
Right, and the second one is also excessive force.
Law enforcement officer who uses
Excessive.
excessive force against a person in a manner inconsistent with this section that does not result in death may be charged with reckless endangerment or assault.
Right, so you
Yeah.
just covered them.
I think that works. Jamie, do you have any comment on that?
Yeah, could you go over that one more time?
Yeah, I'm sorry. So you all knew the first part of the amendment, which is charging the commission to incorporate those definitions into its policies.
Right.
Okay. So when we turn to page 6, 10-802A will now say a law enforcement officer may not use excessive force. And then maybe B would define excessive force, the way we did earlier. And then
Strike everything else.
Then you'd strike everything down to C, and C would say, a law enforcement officer who uses excessive force against a person in a manner inconsistent with the section that results in death may be charged with manslaughter or murder under Title II, Subtitle 2. And then in Part 2, a law enforcement officer who uses excessive force against a person in a manner inconsistent with this section that does not result in death may be charged with reckless endangerment or assault under Title III, Subtitle 2 of this article.
Senator Sidner, go ahead.
I'd like to make a motion just to pass this section clean.
What?
Second.
Well, we got motions on motions, so we got to either,
Well, no, motion second.
I understand, but
West already has a motion.
West already has, so we can, unless the senator is going to withdraw it, we run this first and then go to, we get to go to Senator Sidnor's motion.
If it fails, we'll go to Senator Sidner's.
So, all right, so Senator West, I'm not sure I understand the motion.
Okay?
And as you could tell earlier, I'm not comfortable passing this as is because it criminalizes certain things that I think are kind of errors, but not crimes. But I am equally confused by your motion and what it includes and what it does not include. Instead of doing, because there are a lot of ones and twos and Roman ones, instead of doing it, can you do it by line? Like page number and line?
Sure, we're just talking about page 6 now, page 6 and early top of 7.
You starting back on page 2, Jeff, or where are you looking at?
No, page 6.
Just page 6, okay. So, making this up as I go along. So 802A1, no, just the 802A, skip the one in the subparts. 802A will now read, a law enforcement officer may not use excessive force, period. Then we have, and the rest of A is deleted. Then we have B, which will contain the definition of excessive force.
And existing B is deleted.
And everything currently in B is deleted and is replaced by the definition of excessive force we came up with earlier. And then C, which is on page 7 of 11, remains the same, except in each case when the word force is used in the first line, we modify it by the word excessive.
So in that amendment, we get rid of everything above 10802. In other words, we delete page 5 of 11, we delete page 4 of 11, and we delete page 3 of 11?
No.
He's saying everything from lines 1 down would be struck.
I'm sorry, Senator, let me go back. Let me start from scratch.
Why don't you start-
Nobody has it in front of them, so.
Jamie can do it.
So I think those, based on what you've indicated, Senator West, the definitions would probably be moved to a section of the public safety article dealing with the Police Training and Standards Commission. I'm just sort of going in order of what I've heard.
Lines 25 through 33? Or 26 through 33?
So,
Okay.
So, just sort of walking through step by step, the definitions, since they're being, based on the amendment, the Training and Standards Commission would be required to incorporate those into its policies and procedures. Those would need to be moved to the public safety article. So that, unless the committee wanted it otherwise, those would be out of this provision of the criminal law article that's being established. But in 10802, what would happen is you would say a law enforcement officer may not use excessive force, using the same definition of excessive force that the committee had already adopted in 10803 earlier this evening. And that would essentially take up both A and B. Those subsections would be deleted, and replaced by just the phrase or the provision: a law enforcement officer may not use excessive force. And correct me if I'm wrong, but it sounds like in C, so this is on page 7 between lines 3 and 6. What would happen is it would say that a law enforcement officer who uses excessive force, currently it just says a law enforcement officer who uses force, but a law enforcement officer who uses excessive force against a person in a manner inconsistent with this section that results in death may be charged with manslaughter or murder under Title II, Subtitle II of this article. And then I think I heard, correct me if I'm wrong, but it sounds like in between lines 7 through 10, a law enforcement officer who uses excessive force against a person in a manner inconsistent with this section that does not result in death may be charged with reckless endangerment or assault under Title III, Subtitle II of this article. Okay.
A spoil sport here, but if we're importing the definitions, then some of these definitions, if we are importing these definitions and kind of making them the law of the land via the police standards and training commissions, then some of these definitions are inconsistent with definitions and policies we've already adopted in the last 5 hours sitting here, right? So on page 5, line 1 defines necessary force, and it uses the no reasonable alternative definition, but we rejected that definition earlier. Line 4 defines proportional, implying, what's that? And we specifically rejected proportional.
Can we vote on this motion and then come back and address specific issues with, I mean, assuming this, there's no reason to address this if it doesn't all change. If we vote on Senator West's motion to move this to public safety, and then we'll come back and make changes
And
to these definitions as needed? Can
That's
we do
fine
that?
with me, as long as we're coming back to it.
Fine. And I agree with some of what you said. In fact, I think I agree with all of what you said.
All right, let's get. You found the inconsistencies in the definition. Could that be done with the corrected one?
Well, I mean, maybe we want to go through this and instead of deciding what to cross out, just kind of check mark what we want in? Is that, because I think Senator Carter wants almost all of this in, and I think we can get it, but I think we should just go by it, through it one by one.
All right, it's been there's been a motion, it's been seconded. Does everyone understand what you're voting on? No. Okay.
Are we going line by, I thought we were going line by line.
No. So he was doing something different. We're voting on what? Yeah. Senator, Vice Chair Walsh was pointing out the inconsistencies in the rest of the, yeah, you got it. Okay.
Vice Chair Waldstraker.
Yes.
Senator Lee.
No.
Senator Castley.
Yes.
Senator Huddleman.
No.
Senator West.
Yes.
Senator Sidnor.
No.
Senator Jackson.
Yes.
Senator Bailey.
Yes.
Senator Carter.
No.
Senator Huff.
For vote number 6, yes.
On it.
Chairman
down on
Smith.
it. Going down on it. Jeez.
What?
Yeah. All right. So. Anything else? No, he's got to do these other changes.
To go back and amend the definitions to public safety. We're done, it's just that we're moving all these to public safety, and we're gonna, there are inconsistencies and stuff that we need to go through line by line and say what we think and what we don't.
Mr. Chairman,
Yes.
in deference to Senator Waldstraker, I think he's right. I'm perfectly happy to remove the definitions of necessary force and proportional.
What page are you on?
On page 5, oh man, too long.
Just hold on. Do we have to do? Is this something that? Do we just to conform with those? Just to conform with the same definitions throughout? Let's do. You'd have to strike them, or
Well, I mean, based on what the committee just require the Training and Standards Commission to find a way to incorporate those definitions into their the training standards that they've developed. So they would, I guess technically, where that would go is in the public safety article, And I'll need to scan through the bill, but I don't believe that any other provision of the subtitle, unless it does, uses a definition that's found earlier. I'll have to double check that.
Hold on. I was going to say, is there, rather than going through line by line, we've already done the definition for excessive force. Is there just a way to do one big conforming amendment? I mean, it's just not, no? God.
Up to you.
Yeah, we're gonna pass on. Okay, is there anything else? Senator Carter, Senator Sitter, is there anything else that we need to address? Is there any other points of contention, anything else in this bill needs to be addressed? Jamie, is there any other section we haven't reviewed yet?
Um, 10805.
What's
which
that?
is the penalties provision,
For what? Section for the...
the whole subtitle.
Shit. No way. He can't. What do you all feel like tomorrow? What time do we have floor tomorrow?
We don't, we have 11.
And we're all sleeping down here tonight now.
We have hearings at 11.
We have hearings 11. What about, you guys feel like, shit, we have caucus then, don't we?
I have no idea.
Yeah, let's do that. So we'll push our hearings back. We've got, some of us have caucus. We'll push our hearings back, and we'll finish this bill. It's the last bill. We've only got one more section left and some other smaller items to do some house cleaning. So let's start, if our hearings are going to, traditionally, hearings would start at 11. Let's start hearings at 1. And that'll give us from 11 to 1 to vote. Yes, Senator Carter.
I know it's pretty tight, but is it possible for us to get a copy of what has been determined? It has been a little hard to follow.
So,
And I want to make sure when we come in tomorrow, we know exactly what is determined.
we'll do our level best, but you have to understand that all the work that's been done throughout the day, council has to put that together and draft that. So you may or may not have, it's just the human limitations.
I completely understand. It
Yeah.
is just really hard to work off of no document.
The alternative solution would just be, then, look, we'll come back and vote again after hearings. Keep hearings at 11 and then vote right after that.
I don't know.
That way you'll have an actual copy of what.
Oh, okay. I don't care, whatever you all want to do.
Okay. I mean, you're just swapping time around, so let's do that. Okay. Thank you all for the work tonight.
Wait a second, what do we decide?
So we're starting here, hearings are just gonna start at 11, we're gonna vote after hearings tomorrow.
Floor session Friday, right?
You do, but we also have, so we have, yes, there are 2 floor sessions on Fridays. We have bill hearings that start at 10 a.m. on Friday and bill hearings at 2 p.m. on Friday.
Okay, we'll roll with it.
Plus, I'm supposed to get my vaccine Friday. Feel immediately tired or anything after the vaccine?
Next day.
11 o'clock, right?
Yeah.
Yeah, 11. Okay.
Will.
All right, that's it for the night. Have a good night, everyone.